ಸಣ್ಣಕ್ಕೋ
బస్ స్టాప్ అన్న చెప్పి రారా అని నేను అంచెట్కి ఉంటాను ఊర్లో ఆయన నేను 9:30 10 అవుతుంది ఊరికి వచ్చే వరకు ఇక్కడ 8కి ఇడిచేది నేను 8 o'clock ఆయన ఏమప్పా నేను చెప్తాను నువ్వురా నేను చెప్తాను సర్వ నెంబర్ ఏమన్నా వేరే ఉందా డాక్యుమెంట్స్ 1913 ఇంకా వేసిడಲ್ಲ ఈసీ 1930 20 తీసేయాల ఇప్పుడు గంట
ಮಾಡ್ಕೊಳ್ಳಿ ಸರ್.
Yes. Yes. Mr. Counsel, for withdrawal, your party has signed memo. Why? What is the urgency for tomorrow? What happened in the suit? Who are you? What happened in the suit? Ejectment. Your tenant or landlord? Absolute owner. What happened in the suit? Guttilla, take it and post it next week sometime. What is the urgency? ಮನೆ ಕಟ್ಸ್ತಾ ಇದ್ದಾರೆ ಯಾರು? ಮನೆ ಕಟ್ಸ್ತಾ ಇದ್ದಾರೆ ಅಂದ್ರೆ ಅವ್ರ ಹತ್ರ ಪ್ಲಾನ್ ಎಲ್ಲ ಇರ್ಬೇಕು, ಓನರ್ ಇರ್ಬೇಕು ಅವರು. ನೀವ್ಯಾರು? ನಿಮ್ಮ ಹತ್ರ ಪರ್ಚೇಸ್ ಮಾಡಿದಾರ ಅವರು? ನೀವು Sir, whether you have purchased or they have purchased from you. You read the file and come at 1:30. Only you can move at 1:30. Don't come simply without reading the file, or at least you should know something. Come at 1:30. Next week. Thursday or Friday. So out of two matters, one is before DB. No, whether both the matters are before me.
All the matters, the selected matter is also before the court.
All right, release day after tomorrow. ಮೈಕ್ ಕೆಳಗ್ ಮಾಡಿ, ನಿಧಾನ ಮಾತಾಡಿ. ಮೈಕ್ ಕೆಳಗ್ ಮಾಡಿ, ಮೈಕ್ ಕೆಳಗ್ ಮಾಡ್ರಿ. ಸ್ಟೇ ಕಾಪಿ ನನಗೆ ಅರ್ಥ ಆಗ್ತಾ ಇಲ್ಲ ನೀವು ಹೇಳ್ತಾ ಇರೋದು. ಸ್ಟೇ ಕಾಪಿ ಕೊಡ್ಬೇಕು ಅಂತ ಯಾರು ಕೊಡ್ಬೇಕು? You are able to understand what he's saying? Application ಹಾಕಿದ್ದೀರಾ? All right. When do you want? After 2 days. List it after 2 days. All right. When do you want? Day after tomorrow. Who are you? Your objector or you? Where? In RFA. What's the position in the execution court? You don't know. All right, posted after 2 days.
Page number 8, serial number 31 to 35.
Yes.
But RFA will not, as against the many owner and CCC subjects, that appeal will not be dismissed. I apply for certificate copy, where is it before you want it, and then
Serial number 31.
31.
Yeah, suit for ejectment.
Super ejectment. Between the lessee and his tenant.
Who are you?
I am for the lessee. There was a litigation filed by the owner against me.
What happened to the suit?
That suit was dismissed, and I filed RFA. Now RFA is also dismissed. I have also filed.
No, when the suit is dismissed, why you will file RFA? You are the tenant.
No, I have filed a suit for declaration as well. Street performance. Two suits were there.
So-
My suit was dismissed, his suit was okay. So two appeals were filed. Now the appeals were admitted and more than the last 2 weeks back, the order has been brought to this. So this is my appeals. I applied for certificate for that.
In the specific performance suit which you challenged.
That appeal is also dismissed and the appeal has against the order of rejection. Where is it before you want to know that?
Request of learned counsel for the appellant relist next week. Next week. Next week. Yes.
Page 9, number 36 to 42. Orders. Serial number 1, Mr. Narayan Sharma.
I appeal for the appellant, both the cases. It appears Mr. Wadaya has
Who's
retired.
Prithvi? You want to retire? Who has filed? Abhinav. Yelidhara. Who appears for Abhinav?
In fact, Abhinav telephoned to me and said that he will seek time. I don't know, he has not yet appeared. He has filed wakalat, that's what he informed me. With the
All right. Barkali, learned counsel Sri Prithvi Odayar has filed a memo seeking to retire. For R1, seeking to retire on behalf of respondent number 1. It is seen that learned counsel Sri Abhinav R has already filed NOC wakalat for R1. In view of the same, learned counsel Sri Prithvi Vadayar is permitted to retire from the case. The registry to delete his name from the cause list. Yes, Mr. Narayan Sharma.
Yes, my lord. In a second case, they have said that paper book is necessary, and I have not yet filed. I may require at least 2 weeks time to comply with that, and it has to come up for a hearing afterwards. They are connected with each other.
Learned counsel.
One paper book I have filed already in the first one.
Learned counsel Sri Prithvi Vadayar has also filed a memo in the connected matter for retirement. Full stop. And learned counsel Sri Abhinav Ramanan has filed wakalat for respondent number R1 in the connected matter RFA 966 of 2017. Hence, in view of the same, registry is directed to delete the name of learned counsel Prithvi Vadayar as counsel for R1 from the cost list. Paper books to be filed within a period of
3 weeks, my lord?
2 weeks.
2 weeks. 2 weeks.
Yes. Already order agidya no? Posted before. Still the valuation. It is seen from the valuation para 15 of the appeal memo that the plaintiff, the appellant, has valued the present appeal, the purpose of jurisdiction and court fee at rupees 35 crores. The suit was filed for the partition and separate possession of half share. Full stop. It is the claim of appellant who is the defendant before the trial court that he's also seeking half share in the suit schedule properties, and the value of his half share would be 17 crores 50 lakhs as described in the valuation para filed by the appellant. Full stop. In view of the same, the subject matter of the appeal being more than 15 lakhs, this matter would have to be placed before the Honorable Division Bench as per Section 5(1) of the Karnataka High Court Act. Hence, registry to place this matter before the Honorable DB for consideration. There are counsel for the appellant to file second suit. Same order. Anand. It is seen from the para number 15 of the appeal memo where the appeal is valued for the purpose of jurisdiction at 30 lakhs. The appellant, who is the plaintiff, seeking half share in the suit schedule property, and yes, 15 in the amount. Claiming 15 lakhs. The appellant share is valued at rupees 15 lakhs. Therefore, the appeal would be maintainable before this court as the same does not exceed 15 lakhs. Office objection is overruled. Place not 15 lakhs here. Now, IA is there. Who are you? They are not served copy on the other side. You're a party in the FDP. What is your rank? What were you doing from 2018? No, that doesn't give you cause of action to revive a dead, stale claim. When? When did you file wakalat? Recently? Recently, and very easy to say recently. How was recently? How short was this recently? You have recently joined. Your office has recently filed wakalat. That recently is more than 1.5 years. For your information, that recently is more than 1.5 years. Your defendant number 4. Huh? You purchased from whom? Sir, in the suit, you are defendant number 4. From which defendant you purchased? Respondent. I don't know how to argue the matter. Who's respondent number 4? You purchased from respondent number 4. Defendant number 2. Defendant number 2 anta. What is the status now in the FTP? You're in possession. Where is that proceedings? Where is that proceeding of FTP? They're auctioning. Where is it? Discuss tomorrow. Mr. Gangadhar Aital, I have adjourned your matter. ನಮ್ ಕೈಯಲ್ಲಿ ಅಷ್ಟು ಹ್ಯಾಂಡಲ್ ಮಾಡಕ್ ಆಗಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು 2 ಜಡ್ಜ್ ಕೂತ್ಕೊಂಡು ನಿಮ್ ಕೇಸ್ ಡಿಸೈಡ್ ಮಾಡ್ಬೇಕು ಅಂತ ಅಲ್ಲಿ ಕಳಿಸಿದೀವಿ. ನೀವು ಅಷ್ಟು ಕೋಟಿ ನಮ್ಮ ಮುಂದೆ ತಂದ್ರೆ ನಮಗೆ ಡಿಸೈಡ್ ಮಾಡಬೇಕು. Yes. So in view of it being more than 15 lakhs, I have directed the registry to place. No, it's okay. So before DB, you may have to file second set. Sorry. So you are giving a caveat that every day if you are late, I have to pass some order. So yes. Filing today. All right. Learned counsel submits that you paid the cost also. Submits that he has paid the cost as ordered by this court on 20th April 2021. He seeks time to comply with the objections. A week's time is granted to comply. The discrepancy is in which schedule? For delay. One is for delay. One of 2 of 19 year pay kama. One is a delay application. So IA 2 of 19 is an application filed by you under Order 39 Rule 1 and what is the discrepancy in the schedule? Seven of Hmm. That's a sale deal. Whether that is a schedule in the plaint. So what is your reply to the objection raised? What is your reply? There is a plaint, madam. There is a plaint. What the objection? No, not matching with the plaint schedule. There is a schedule in the plaint. Ah. Yes, where is your schedule? Yes, in item number 1, 2, and 3 are shown in the plaint. Yes, now we are seeking injunction of C schedule property 101A on the first floor commercial complex. Where is that? Who are you? No, this appeal is filed by whom? You're an objector in the execution petition. So you have filed order 21 rule 97 on. So suit was for partition. Have you filed the execution petition? What is the execution filed for? What is your relationship with the JDR? What is your relationship with JDR? Huh? What's the relationship? Is there any relationship? So your case is that you have purchased this property. What is it? Is it a flat or it's an independent house? What is the stage of that proceedings? FDP or execution? What is the stage? What is the stage, madam? Yeah. All right. Read this matter as council after next week. Next week. Hmm.
You know, you don't have quite what happened. What is that? What has happened? You know, it was the itself has, you know, himself has gone because that happened.
The officers raised.
Last night,
Gave it not filed and then
Give it not right.
the objection. Caveat.
First time I can do
All right, we'll overrule that. There are other objections raised. 2 more objections are there.
Last time it was not there.
The office can create, sir, new objections. So you have to one vehicle Madia. This is my minor objection. Really, one is IA for CD to be filed full cost title and delay. Second is page 67, 68 of judgment to be stitched in correct order. Maybe front and back ಆಗಿರ್ಬೇಕು. Learned counsel seeks time to comply the objections. 10 days time granted. Learned counsel caveat ilvalla. There's no need. No caveat. There's no need to serve. Adidre, you can take it back. Office has committed a mistake. Yes, madam. So there's non-stating of number of delays. All right. What is the objection and what is your reply? Your IA for stay under injunction. IA for? All right.
Then the market value of the property,
Hmm.
the case was filed, valuation is approved, so they were being that. Now subsequently, I will produce, I filed a memo, the property actually, signed by that memo, I already filed, but that is the memo on this year. Memo filed.
Hmm. 12/7/19.
Yes, memo on this year. And including illustrated safety.
No, this is appellant submit prior C in the said appeal is consequential.
There are 3 memos. All 3 memos are rated to accept.
Appellant submit current market value of rescheduled property is 24 lakhs.
And my lord, get tax safety. It's free of safety.
What is the value of the property now?
I have purchased a site out of the entire check. My contention, the site is valued at 24 lakhs. That might not be there.
All right, we'll go by your 24 lakhs. Next. No, how, what further? 24 lakhs is the value of the property you have purchased. Now, your case is that you are a third party purchaser. All right. All right. All right, you are not made a party. So what you have valued the suit for how much? No, the appeal, the appeal. Appeal is valued for 24 lakhs, madam. Admittedly. So then this will have to go before DB. That's all. So you rectify all other things there before the DB. All right. So you'll get some more time. Learned Counsel Srimati B.V. Nitishri is present before the court. She has filed a memo dated 12/7/2019, subscribing to the fact that the market value of the B scheduled property, which is questioned before this court, is valued at rupees 24 lakhs. The same is also forthcoming in para number 31 of the appeal memo, wherein it is clearly mentioned that the appeal is valued at rupees 24 lakhs for the purpose of court fee and jurisdiction. Therefore, in view of the fact that appeal is valued more than rupees 15 lakhs, and as per section 5(1) of the Karnataka High Court, sir, this appeal would have to be placed before the Honorable Division Bench for consideration. Registry to list this matter for the Honorable Division Bench. Learned Counsel for the appellant to file second set and comply with the objections, if any. Now, whether is it before this now, today? Even if you make and I hear what is the purpose of it, I cannot pass an order. So that is also similar. So we'll have to go before DB. Then you can list, file a memo. Now we'll call it whenever you want, tomorrow, day after. Put your green sheet, put your madam. Yes, Lakshmish. On complaints, 2 weeks time granted to comply. Peremptory order is there. 2 weeks time granted to comply.
Serial number 11, I appear for the appellant, my lord.
2 weeks time granted to comply.
Much obliged.
Settled. Senate Counsel for the appellant submits that the matter has been settled between the parties, and she seeks some time to file the necessary memo for
21.
hence release this matter after 2 weeks. Two weeks time granted to comply. Rashid Khan, 2 weeks time granted to comply. Learned Counsel, your Chetan, Learned Counsel Sri Chetan AC, present before the court, files a memo seeking permission of this court to withdraw the appeal. Memo is placed on record. Memo reads as under. We have the submission and the memo. Appeal is dismissed as withdrawn. What is this suit for? Your appellant. Have you paid court fee? Huh? How? You're a plaintiff appellant or defendant? You're the defendant. Dismissed as withdrawn. Same order. Same order. At request of Learned Counsel, a week's time is granted. R6 is left, huh? So you want to take steps. R4 is the mother of R6. All right, but she'll have to be. Suit or partition. Who are you? How can he sell them?
I'm deciding that property.
You are one of the son.
Yes, son and the mother are residing. There was no intermother since the balance. But the parties which he is seeking in exemption is actually different response number 4 and
All right. Which is that application? All right. Yeah, we served a copy on it. Then it counsel for the respondent 1 and 2 submits that he has filed an application for temporary injunction registry to verify and put up. Next week. Arun Ashok.
My lord, this matter may be dismissed as not pressed, my lord. My lord, I'm appealing for the appellant.
You file a memo.
My lord, I'm today out of station, my lord. By tomorrow, I will place it on record, my lord, in the registry.
So you send one by email today.
Please, my
Tomorrow
lord, I'll send it by email.
Hard copy, original copy you can give tomorrow. Whose appeal
Please,
is defendants? Defendants appeal.
My lord, this is with respect to specific. No, my lord, it is a plaintiff's appeal only. This is with respect to specific performance. The matter was compromised. Some of the amount was not paid. That
So
is
you
when
don't have your
the
file.
party has come to me and
Don't have your
I am
file.
out of.
Then don't make wrong
I am in
submissions.
Hubli
if you
right
don't
now
have file.
because of my father.
Don't make wrong submissions
Sorry.
if you don't have file.
I'm sorry.
But counsel for the, what's your name?
Arun Gadag.
Arun Ashok Gadag is present through video conference and submits that he seeks leave of this court to withdraw the appeal. He submits that he will email a memo for withdrawal of this appeal and he would submit a hard copy by tomorrow. Placing his submission on record, this appeal is dismissed as withdrawn. Yes. 3 weeks time.
Hello. Hello. हाँ शर्मा अभी देख उसका स्टेटस का ना ऐसे हो रहा है तो मैं कलीग से बात की है वो क्या बोल रहे हैं कि लीगल नोटिस भेजना पड़ेगा यूनिवर्सिटी को ठीक है जैसे हमने
You have served to whom? Which respondent?
अभी नहीं हुआ तो उसके बाद देखेंगे मैं करती हूँ मैं एक लीगल नोटिस और तुझे भेजती हूँ। हाँ मैं कल करूँगी, अभी काम है, करके कल सुबह भेजती हूँ।
You already have an interim order.
It is already admitted. Twenty-three, 3/8/21.
Relist this matter after service of notice. Interim order to continue.
23. They are clean.
Appellant, my lord. I'm for the appellant, my lord.
Yes, Mr. Dayalu.
My lord, actually, my lord, there is no valuation slip filed in the trial court, my lord. The office has raised the objection, valuation slip to be filed. There is no valuation slip filed, my lord, in the trial court. That's why I cannot produce the valuation slip. It may be overruled, my lord. They wanted.
What is the value of the property? Who are you?
My lord, I am for the one of the defendants, my lord. She had she had a counter claim, but had undertaken to give the court fee if counter claim is allowed. Counter claim was not allowed, and it had not been valued in the trial court. So I cannot value the property afresh, my lord. It's a partition suit.
What share are you seeking?
I am, my lord, in respect of one property, my lord, claiming that that property should come to her. Your lordship may kindly at page number, my lord, filed the valuation slip, my lord, wherein I have stated, my lord, lordship could see the 103 at page 103, my lord, 100 to 103, my lord, wherein all the valuation slip, all the defendants is produced, and only this defendant had not filed the valuation slip. I cannot produce the same, my lord. Your lordship could see at page number 105, my lord, wherein I have stated defendant number 6 has not filed valuation slip and has stated in his written statement that she undertakes to pay the court fee for the relief sought and has not paid the court fee. Hence, valuation slip detailing above. No court fee had been paid in the trial court.
You are defendant number 2.
I'm the defendant number 6, my lord. Appeal is defendant number 6. Nirmala Bai.
So defendant number 6 did not file any counterclaim.
She had counterclaim, but she had not paid the court fee, and valuation slip also had not been produced. I challenge the entire judgment and decree, which is a partition suit.
All right. So what is the value of the entire property?
It had been valued 200 rupees court fee is paid, madam. Same court fee is paid here.
The court fee is different, valuation different.
Valuation, it is mentioned, my lord, a decree.
28 lakhs 50,000 ಅಂತ ಹೇಳಿದ್ದೀರಾ?
ಇಲ್ಲ 100, my lord, 100 to court fee paid is 200 only, madam. Lordship could see at page number 100, my lord,
I'm having 100.
wherein the value made is 200 rupees. I mean, court fee paid is 200, my lord.
Mr. Dayalu, partition suit ಅಲ್ಲಿ court fee ಬರೋದು 200.
Sorry, my lord.
You can have some water.
Sorry, my lord, I am not well actually.
No, you can have, there's no urgency. You can have some water, no problem. Now, the question is, what is the market value of the property to decide jurisdiction?
That is written in valuation, Lordship could see 70,444. Total market value of the suit property for the purpose of court fee, 10 lakhs 633.
That is included. You come to 102.
Where?
This is showing as 28 lakhs.
28 lakh 50,000. The value of suit property for the purpose is 28 lakh 50,000. Defendant number 2 claiming 1/3 share, 9 lakh 50,000. And 200 rupees court fees paid. I've challenged the judgment to decree. She has not paid any court fee.
What is the share you are seeking now?
The same share, but except one property where which I claim to be my, it should come to me after my husband.
Yes, to 1/3 share.
That is not valued in the trial court. That was the problem, my lord.
Don't worry, sir. You file now a fresh valuation.
Oh, please.
Valuing the market value. And what is the share you are claiming? Karnataka.
Lordship may observe so that it would be.
Yes. I don't know whether you have infected me or I have infected you.
No, well, I have not come there that way.
Good. Senate Counsel Sri Dayalu, appearing for the appellant, submits that before the trial court, valuation slip was not filed by the plaintiff and the defendant.
And that not valued also.
He appears for defendant number 6, who is the appellant before this court. He seeks a week's time to file a proper valuation, valuing the suit properties for the purpose of jurisdiction of this court.
Please,
not court fee. File it. Released after you want to 2 weeks.
Please, man.
2 weeks.
Much of
Convert this into civil revision. Then the order 7 rule 11. Allow agide, reject agide. Rejected. So if it is rejected, then you can't file appeal. What you have to file? Perfect. Senate counsel for the appellant, you are Bhattegowda? Bhattegowda is present before the court physically. He has filed a memo seeking to convert this first appeal into a civil revision petition in view of the fact that the order, impugned order that is challenged before this court arises out of the application filed under Order 7 Rule 11A, read with Section 151 of CPC. Said application came to be rejected. Full stop. Submission of learned counsel and the memo is placed on record. Registry is permitted. The appellant is permitted to convert this appeal into civil revision petition. Full stop. For statistical purposes, this appeal stands disposed. Memo kidara. It is seen at valuation para number 7 of the appeal memo that the appellant has valued the present appeal for the purpose of jurisdiction at rupees 16 lakhs. The appellant was none other than the plaintiff before the trial court. The suit came to be dismissed. Full stop. In view of the value being more than 15 lakhs, as per Section 5 of the Karnataka High Courts Act, This appeal would have to be placed before the Honorable Division Bench for consideration. Accordingly, registry to place this matter before the Honorable Division Bench. Learned counsel for the appellant to file second set.
Appellant by me.
Yes, Mr. Ang.
Appellant by me.
Yes, you have received the copy.
No, I have not been served matter.
Not served. What is this IA? So you are seeking for return of this original sale deed, exhibit P8. Who are you? Yes. Yes, Mr.
Please, my
Angadi.
lord. Yes, my lord.
So this P8 was marked by you, produced by you. You are the plaintiff. You have any objection in this document being returned?
I have no objection. He has to place a certified copy of the same.
That we'll order.
Yes, that's all.
All right. Shall I take it that you are consenting or you want an order of the court?
Let the order of the court, my lord.
The matter is admitted or?
They have not been served with copy, my lord.
Non-filing of paper book.
Lord, for that I have 6 weeks time.
All right. Barcode. Learned counsel Sri Amaresh A. Angadi is present through video conference, appearing on behalf of appellant. And learned counsel Sri Prakash M.H. is present before the court physically for the respondent number 1 and 2. Full stop. Learned counsel for the appellant seeks 6 weeks time to file paper book. Same is granted. Full stop. Para. Learned counsel for the respondent number 1 and 2 has filed an application seeking for return of original of the sale deed dated 10/11/1972, which is produced and marked as exhibit P8 before the trial court in OS number 3197 of 2013. Full stop. Learned counsel for the appellant submits that he has not received a copy of the application, but however, having gone through the application, it is seen that what is sought in the application is only for return of original sale deed, which is marked as exhibit P8. Full stop. Are you disputing anything in this exhibit P8?
No, my lord.
In view of the fact that the original document is marked as exhibit P8, I do not find any legal impediment in allowing the application and directing the registry to return the original sale deed dated 10/11/1972 marked as P8 to the respondent. Which respondent? Respondent. No. Here, which respondent? Respondent number 1. RFA 320 of 2022. RFA 320 of 2022. Full stop. Learned counsel for the respondent is permitted by registry return the original copy of the sale deed exhibit P8 to the learned counsel for respondent upon proper verification, and after obtaining a certified copy of the same to the satisfaction of the registry. Stop. And he shall produce the original sale deed as and when called upon by this court.
Our difference is that in the loan transaction, it is not a transaction of sale of the loan or show the bona fides.
Regarding all right, that is your case. What do you want to file? So this deposit of the amount. Specific performance suit. You are the purchaser, he is the owner. What happens? Suit is decreed. Direct him to register by receiving 1 lakh. You have the 1 lakh before the trial court. All right. So what do you want to do now?
Are required to plead also to the fact that refund of the unless money that was paid. That means not that, not to stand legal like not to not to show my bona fides that it was a loan transaction and I was to go to repay that money. And I will not so far as the interest is concerned, I am legal to whatsoever on the data they I'm not going to pay any. Unless money, whatever the loan amount was paid, I have taken the leave of the court and I have dealings also. Not to establish my bona fides that I am interested in returning the money that I have given go. Others, the defense have taken. The challenge is a thing.
You're filing objections to this. Copy or copy, jara. Badly. Give it. File it in the registry.
They are not even made any single attempt before a trial court, not before the High Court. This kind of attempt to deposit a certain amount. If you are borrowed, if you are loan to register property in a not a very serious, serial number 61 of the paper. They have an application for produce of additional document. Their objection is affidavit from the judge. Clearly states, even the amount of it was their contents. 2008 ಆಗಿರೋದು ವಿಲೇಜ್ಗೆ ಖರ್ಚಿಗೋಸ್ಕರ 2014 ಸಪೋಸ್ ಲೋನ್ ತಗೋದರ ಕಂಟೆಕ್ಸ್ಟ್ ರೇಟ್ ಈವನ್ ಅಲ್ಲೂ ಸಹ ಯಾವ್ದನ್ನ ತಗೊಂಡ್ರ ಲೋನ್ಗೆ ನಾನು ತೀರ್ಸೋದಕ್ಕೋಸ್ಕರ ಲೋನ್ ಮಾಡ್ತೀನಿ ಯಾವ ಕಂಟೆಕ್ಸ್ಟ್ ಕಾಂಟ್ರಾಡಿಕ್ಟ್ the whole statement before honorable. These are the tactics which take a letter to before honorable court to own it after percent.
2014 is agreement of sale. Now you are in possession of. It is not given to you. You are in possession.
They are making it out.
All right. Learned counsel Sri is appearing for the appellant profits that is filed an application in permission is court to deposit. Huh? 75. For what? You want me to hear that application now and decide? What's the purpose of your argument of seeing page number 75? You want me to consider your objection or you want me to pass orders? I filed an application IA number 1 for permission to deposit certain amount. Learned counsel for the respondent intends to file objections to the same and he has furnished a copy of the objections to the learned counsel for appellants. He is permitted to file the objection before the registry. Release this matter next week. Go through and submit arguments on the IE, then we'll consider. On the next day you come ready. Yeah, finally. It's a matter of stay. Writing a lakpadi Swamin said. A court can pass only order on the framework of law. We cannot say anything. And trial court is bound to do as per law. We are not dictating the judicial officer to do anything beyond the framework of law. Yes. Fine. Sir, have you taken this plea of deposit of this amount before the trial court? Okay. Correct, but nothing prevented you from taking this plea at the first instance when he said it is an agreement of sale. Yelli. Yes. 2014. Now 14 lakhs you can deposit. So now it is apparent that you have collected this amount from him. There is no dispute.
Property value was much more. And what it was, as was paid of the agreement.
When circumstances go bad, you bigger property, you may sell it for lesser price.
For refund of the assessment. If it is not compliant.
Eat for refund. No, he doesn't want refund. He wants execution. Alternatives. Alternative. He doesn't want an alternative. It is his choice. He's the dominus litis. Can you dictate?
Not seeking for any. Many people are really interested.
All right. Yes, yes. Next. Yeah, dismissal agide, no?
Calculation. No calculation.
Appeal came to be dismissed. Yes, appeal is dismissed. What was ordered? Huh?
3 months in a taker, not to proceed with the case, the vendor sold the property to my vendor. And it's sold to be 2015. In the same day, between the appellant and the subject, my vendor, there is a clear recital that they have received the entire statement. Delivered this entire project. Knowing the schedule, they have shown the ground floor and first floor. Second floor portion was not shown. As I have indicated earlier, to save this category, they have mentioned. No part of the sale deed exemption that vendor has repaid a portion of this. So, with the undivided interest in the land, the entire boundaries and residential is shown and sold to us. It is in fact entire property is sold to the possession of the based upon it, Karnataka is also after 3 years of purchasing the property, you sold the property to me, 2015. Based upon that, I filed a suit for OS 4917 of 15 for ejectment of the mean profit. Ejectment, the court to consider it is a permissive question, vendor is going to purchaser as per section 54 of the Act. 3 months time was granted. With regard to the mean profit, I have filed because it's a technical case. No mean profit would be granted in this case. That is why I am made to file a separate appeal connected with this appeal, my lord. Therefore, your lordship has directed me to file a memo of calculation. Since she is deciding in the first floor, she claims to have resigned the second floor of the balance of alleged status. What paid the vendor? Your lordship directed you inherit fruits of second floor. Deliver back to my first floor. Since it covered under the state date, like your appeal, he has filed a suit for a ejectment in respect of the second floor, and also sought for main profit. Like you proceed with that suit. This suit to clearly come. So the highly directed run and wrote the memo of calculation to show 10,000 rupees is the rate of rent for 9 years, 91 months, 9 lakhs 10,000 rupees. All the charges she has not paid, 200 rupees average, it comes to 18 lakhs 2,000, 9 lakhs 58,200 is payable. And as far as my appeal is concerned, with the direction, I will withdraw the appeal. This is, we permitted to file this.
So the RFA 330 is filed by, and you have filed RFA 577. Mean profits. So these two appeals are arising of one suit, OS 4917. So you're in possession of other floors except first floor, is it?
Yes.
No, he was directed to vacate first floor and hand over to you. So you're in possession of ground floor and second floor. So you have filed execution to execute that he should hand over first floor. Mean profits in Madhuri reject agide. Other mail challenge madidira. Your appeal is challenging the mean profits. This appeal is against the order of ejectment. So what is your contention now? What is your argument now? That you will withdraw your appeal. So total arrears is?
Yes, 9,28,000. It is here.
9 lakh?
28,200. For 91 months. From the date of purchase to pay date, 91 months, 2015.
Now this defendant is your tenant.
He is a vendor to my vendor.
Vendor to your vendor. Original. So you have not paid any amount to him.
There are people who sold the property. If I say they are immediately out of the city of the cost, not back of the city. There are people who I understood this right. If they say I was trying to there are times when the vendor, city pick up the fire, and say that. Apart from others who maybe get the responsibility, second problem. The immediate response, second responsibility.
Have you initiated suit for that? In which number? Which suit have you filed?
It is there.
9057/18. So this suit is filed by you for ejectment or possession. Possession of second floor. Yes. What happened to that suit? All right. All right. So your suit is still pending. His suit is already decreed. Now you are occupying his portion, first floor, free of cost. All right, you prosecute. Go and establish. What is the amount he has to pay you? What is the amount he has to pay you?
So you have 9,72,000.
I deposit that amount. Admitting. You are in possession of ground floor and second floor. According to you, that belongs to you.
Entire property belongs to.
Where is your sale deed?
Yes.
Yeah, records is here. Madam, your records are here. This is coming up for IE. Exhibit.
We did. I did the contents. Page 5.
Will quote your entry. I've given in this itself. What is the deed? Sale deed dated?
26/4/2001.
26/4/2012. TL Shanta in favor of Sandeep. Sandeep is your vendor. All right.
Your Lordship may kindly take it to page 4, bottom 2 lines.
Page 4 of the sale deed.
Page 4, last 2 lines. Going to display.
Page 4. Vendor has thus received. Ada.
Thus, vendor has thus received 17 lakh 40. Nothing more we can do for the purchaser. Next sentence. The vendor has never actually taken all this state the purchaser has taken the produce.
What is the schedule?
Next, when taking a lot of the schedule, page 8, which is submitted to the all the fees and parcel of the schedule. Where in the northern portion of the property, consisting of 5 squares distinctly involved assisted with that windows, the entire boundary surface, measuring this place, no part of the scheduled property is said to have been retained as a vendor towards the alleged balance of sale communication. It is a registered document followed by this. They have executed a confirmation deed at P level. Subsequently, confirmation deed is also been dated 22/8/2001. The order was not available for the first sale deed to consent. The order was having a pregnant, therefore, subsequently, Shilpa Tejasvi, daughter of the Shanta,
Only daughter, huh? Only daughter.
only daughter. The son and the husband have attested the confirmation. In this also, they recited with mentioned in the confirmation deed. At a P11 exhibit.
Yes.
Same schedule is shown like that.
So as on date of the sale deed and confirmation, whether there existed any second floor?
Yes,
There.
it exists.
There existed,
Yes,
but it is not mentioned here.
yes, as I said, to say this and deed. Where these are one of the method they adopted.
All right, all right. Now you have acquired this property by which deed? Where is that document?
That is a site for purchase, going for market. Subsequently, she has put up the first and second, thereafter she showed to the.
No, you are claiming that you are owner of second floor. Time of purchase? When? When? When did you purchase?
Recital, exhibit P10.
Recital ಗೊತ್ತಿದೆ. You have been reading this file for 5 years. Now I am in 5 minutes, how I should know? Yes. When did you purchase? What is your sale deed? Matter is of 2017, 18. You're claiming title of from when? Registered sale deed. All right, vendor of the respondent now sold it to him. Correct. So now you pay the amount for your occupying. You claim. Sir, we are not bothered about second floor in this appeal. Please understand. Where has he admitted? All right. Where does he say that he's in legal possession of the second floor? You don't establish it before the trial court. Now you deposit that amount if you want to recall that order. Otherwise, it's not going to be recalled. But choice is yours. You decide what you want. You're occupying his floor, admittedly, which belongs to him. According to you, he's occupied your floor. That is between you and his vendor. How is he concerned? How is he concerned? You want to deposit? What is the total amount?
10 lakhs. 28.
What are you giving? What is no? What are you reading? Have you given that to the court? What is that?
It's a memo of calculation. I'm not directing. Prepare a memo of calculation.
Or kote jara. Put it. You one copy here.
Suit that's how damages case. Suit like a copy.
So you are challenging the dismissal of your mean profits here.
Yes. Only observation is issued.
Will you forego your mean profits if he vacates? Huh? I've not thought about it. Yes. Huh? You have two choice. One is you pay the entire amount, what his memo of calculation is. That is the damages which he is claiming for your occupation of first floor. Second, you check with your client whether he wants to forego the interest which you are now trying to claim in the second floor by virtue of the new suit which you have filed.
I want to put an end to all the litigation.
No, correct. Whether your client is agreeable, you check up. Otherwise, you find out when you are going to deposit. Friday. No, not next week. No, this is 2018. This is only to know whether you are going to deposit. If you are not agreeable, then you have to come with the demand draft. Otherwise, your this order of recall will not be done. As it is, your appeal is dismissed. Nim appeal pending. Your appeal is no. Your appeal is not dismissed. It is pending. Huh? So the order which was passed by this court was only in 330. The other matters pending. Order sheet separate. All right. Then at council. This new registral file, Mr. Then council. Your name is Tribhuvan Chakravarti. Then council Sri Tribhuvan Chakravarti is present before the court, appearing for the appellant in RFA 330 of 2018, and learned counsel Sri Ashok Kumar Ashok Kumar KR for respondent number 1 and 2 is also present. Full stop. Learned counsel for the respondent has handed over a copy of the application with the memo of calculations with regard to damages for having occupied the first floor of the suit premises by the appellant, who's the original defendant, defendant. You may file the application before the registry, copy of which is already served. Full stop. Learned counsel for the appellant defendant to find out from his client if he is willing to forego his interest in this second forego his interest in the second floor of the suit schedule property. By accepting the fact that the respondent is the owner of the suit schedule premises, including ground first and second floor. If that is not acceptable, then the appellant defendant to deposit the damages to an extent of rupees 9,28,200 for having. You file your objections for having occupied the first floor of the suit schedule premises, which admittedly belongs to the respondent. Relist this matter on 26th. Its interim order stands continued. Just inform him. Seven and a half plus 6.5.
Here again, now we have almost 8 lakhs. Here also we have. So we need to pay a reply to the memo.
Yes, sir.
Damages.
Yes. Yes, 15,000.
It is fixed. Not questioning. That is existing because it's eligible. How can you do that? Law may not be based. Fiction. Unless they demand 50% per month, then
Yes.
Second time to deposit 19
So what is, according to you, what is the total amount he has to deposit as per this 15,000?
Yes. That's not. Yes, I will take one 445. Can you see, I will bring into account that what the current has deposited. The total amount.
Yes, sir.
Calculation that you. Now, just now, right, the order is per month. Again, don't idea, right, what to do. How the national get is the 447, they are due 16 lakhs 55,000. The first day. The second
No,
day-
no, Mr. Senior Counsel. Yes, yes, yes. ಇದರಲ್ಲಿ ಇಲ್ಲ one ನಿಮಿಷ. Now the order on page 29, what you read, 15,000 rupees per month from date of suit till the date of judgment or till date probably. Was there anything earlier prior to that? Can you show your calculation?
Areas of rent with damages from 1/1/2010 to 25/2/2020. At the rate of 50,000, 80,000.
What is this?
This is for 121 months.
ಯಾವಾಗಿಂದ?
1 month value from the million.
1/1/2010 ಎಲ್ಲಿಂದ ಬಂತು? Where is the order for that? How much you have deposited, Mr. Kamath? Mr. Senior Counsel, ಇವಾಗ from 3/1/2019 is the date of judgment.
2/1/2019.
The date of judgment. So date of suit yavaga?
Suit is 2012.
12. Date of institution is 2012. So you have to calculate from 12. Then you 10 ಇಂದ ಹೋಗಿದ್ದೀರಾ? So let's calculate from 12/7/2012. Yes.
Second round will not below that. Number 2, the order dated 16/2/2016, they were deposited of and photo 18 lakhs 65,000. Then 4 months, then 6,000 rupees.
So additional deposit of 50,000. That is why court order dated 16/2/16. What is that?
Additional deposit, what they claim to have paid. Like, for deduction.
All right, how much they have paid according to you?
Then paid, sir.
How much they have paid according to you?
Now, the detail is 7% in the year by two. The total money paid is last.
6,60,000.
6 lakhs 60,000. Out of 12 lakhs 5,000.
So you are admitting that he has paid 6,60,000. That is as on? As on?
15 November 2017. Allegation, sir, that's 70.
6,60,000.
Okay. Then, again, 25 to 20. In the 25 1 2 3 lakhs 45,000 for 23 months.
Then in calculation, I don't think is correct. Simple calculation, date of institution of suit 12/7/2012. Today we are in 22. 10 years, I think. You add another 2 months because suit institution is July. Now we are in September. So 122 months is what you have to calculate. 122 months is what he has to pay. 122 months into 15,000. All the calculation mark. You are his colleague. 122 months into 15,000 rupees. 18 lakhs 30,000. 18 lakh 30,000. Otherly, if you minus 6 lakhs according to you, what he has paid, it will be 11 lakhs. Then where the question of 16 lakhs 55 balance to be paid by him? Now, after that, after the 660, how much you have paid totally? 14.
Totally we have paid 6 lakh in the 447. We have paid 6 lakhs.
After that? After that?
Now the 2.5 lakhs.
Amele. Nine. So more than 11 lakhs you have paid.
We have calculated that
So, no, you cannot calculate 10,000 in your whims and fancies. But it appears that he has paid more than what you are demanding. Adu nodi. Because date of suit is 2012. Now we are in 22. It cannot exceed more than 10 years. So now you are admitting he has paid 660 earlier. Now he says he has paid another 9 lakhs, 5 lakhs and plus another 4 lakhs. No case idea, no? What is that other case? In the other case, how much is the amount ordered? Then it will be double of that. 18 into 2, 36 lakhs. So 36 lakhs minus around 11 or 12 lakhs which he has paid. Balance he will have to pay. File your memo. What you have filed, you have given it to him? No, that we'll see. Now, 15,000 you lecka madi, ni memo of calculation aki, deduct whatever he has paid on the basis of each case separately. Then you see what is your arrears. We'll have this matter tomorrow. ಗಲಾಟೆ ಮಾಡ್ತಾರೆ. So you do that, sir. ಕೊಡಿ. ನಾಳೆ ಮಾಡ್ತೀರಾ? ನೀವ್ ಹೆಂಗೆ ಇದ್ರು ನೀವು ಚೇಂಜ್ ಆಗಕ್ಕಾಗಲ್ಲ. You are going to be tenant. ಕೊಡಿ. Today is 20th. We'll have it on 22nd. Learned senior counsel appearing for the appellant Shri N. Ravindranath Kamath and learned senior counsel Shri M.T. Nanaya appearing for the respondent are present before the court, and they submit that they would file a detailed memo of calculation with regard to the arrears of amount of damages due from the, in both the case you are defendant, due from the defendant and the amount already deposited by the defendant. Both the learned senior counsel shall exchange their memo of calculations. Let the matter be listed on 22nd. ಎಲ್ಲಿ ಡೆಪಾಸಿಟ್? ಯಾವಾಗ? ಇಲ್ಲಿ ಕೊಟ್ರ? ನಮ್ಮ ಮುಂದೆ ಓಪನ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ. ಅದು ನಮ್ಗೇನ್ ಗೊತ್ತು? Let it be, it will be a matter of record. No, if you have deposited the DD, it will reflect in the order sheet and it will be shown. You have made the DD in his favor or registrar? All right. And we will permit him to withdraw that. All right. ಅದು ಮಾಡ್ತಾರ ಅವ್ರೆ, ಆಟೋಮ್ಯಾಟಿಕಲಿ ಆಗುತ್ತೆ. Additional documents. Oh, now you have given. You have given now. Letter counsel for the respondent handed over copy of A number 1 of 2020 to learned counsel for the appellant, who acknowledges the receipt of same. Yes. Vacating stay has to be heard, is it? Huh? That is the one which is given to you now. Let this IA, let the IA come up next week. 2 weeks. Registry to list IA number 1 of 2020 for consideration. Relist after 2 weeks. ಯಾವ್ದ್ರಲ್ಲಿ? 32 ಅಲ್ಲಿ ಇವ್ರು ಇದಾರಲ್ಲ ನಿಮ್ಮ ಡಿಯರ್ ಫ್ರೆಂಡ್. What is your name? YV Prakash. Yes, Prakash is here. Where is Mr. Sharma?
I am 32. I am there, my lord.
ಇಬ್ರು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ರೆ ಅವ್ರಿಗೆ ಏನ್ ಕಷ್ಟ ಆಗುತ್ತಲ್ಲ.
No, I have sent citations with a list through my colleague, and you watch me kindly accept it, and I will argue the matter, my lord. That's why I sent it through him. The
injunction suit ಪ್ರಕಾಶ್ ಅವ್ರಿಗೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಕ್ ಬಿಡದಿದ್ರೆ ಹೆಂಗೆ?
ಏನೋ ಸ್ವಲ್ಪ ಕಾಂಪ್ಲಿಕೇಶನ್ ಅಂದ್ರೆ now I have filed amendment applications in the appeal. The suit was filed for injunction, my lord. In that the defendant made a claim of counterclaim, injunction in her favor. Then suit is dismissed and counterclaim is allowed. So I filed 2 appeals. One for my dismissal, another for granting a counterclaim. These are the 2 appeals. Now,
so bare injunction suit.
Bare injunction suit was
filed
dismissed.
by you is dismissed.
Claim by her for injunction granted. Yes. Then now what has happened is, during the pendency of the suit itself, the later stages, I was dispossessed. And I did not file an application for amendment in the trial court. And now in view of the dispossession, I have filed an application for amendment seeking declaration and for possession and consequential injunction. So the declaration for possession now I have sought for. My learned friend is opposing, saying that is belated, mainly on that ground. That is why I am referring to these judgments where the
All
test.
right. So you have received that e-copy?
Yes, all long back. I have given it. And he has filed objections also, my lord. He has filed objections also. Now
So you
I
are ready
want.
to argue? ಬರ್ತಾರಾ ಇವತ್ತು? ಅವ್ರು ಪಾಸ್ ಓವರ್ ಕೇಳ್ತಾ ಇದ್ದಾರೆ.
ಪಾಸ್ ಓವರ್ ಮಾಡಿದ್ರೆ ನನಗೆ ಇನ್ನೊಂದು ಪಾರ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಇನ್ನೊಂದರಲ್ಲಿ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇದೆ ಅಲ್ಲೇನೆ. ಐ ಡೋಂಟ್ ನೋ ಹೌ.
All right, then we'll have it next week.
Date may be fixed so that let him also come. He wants to.
Now, Mr. Sharma.
Yes, my lord.
Admittedly, you have been dispossessed.
Yes.
So now your suit for declaration will have to be considered.
Correct.
So there is no great urgency. We'll have it next week.
One more submission I want to make. The urgency is this, my lord. After the decree and during the pendency of this appeal, the first respondent has sold it, transferred it to the second respondent. He came on record filing an application to implead. I did not object, your lordship. This court permitted him to become R2. Now he is trying to alienate the property, that R2 again, to somebody by altering, etc. So I have filed 2 injunction applications, not to alter, not to alienate. So those applications are also pending. That is why the urgency. Otherwise, and one more thing is, ultimately, my lord, the matter requires remand and disposal. There is no question of admission and keeping. In fact, the coordinated bench, when I argued, they said that I will do it and dispose of. Then my learned friend objected, saying that I will argue. That is how it is posted now. So ultimately, it's need not be kept here. It has to go back for remand and.
Have you filed objections to those applications?
Yes, filed.
All right, we'll hear all that on the next week.
Very well. Date may be fixed. I will.
Meanwhile, tell your client not to alienate further.
Yes.
Because it's anyway hit by this pendants.
In spite of lispendence, my lord, if the third party interest is created, that is the difficulty, and the judgment is now the judgment is not in my favor. That is why they are taking advantage and doing that. And after the decree, the sale deed is executed. And
already he has created. Already he has alienated.
No, the difficulty is he is also known to each other and created. Now they want to sell it to third party. Correct. That is why I filed the application. And ultimately it has to be inquired into, and that is why I said further. I said yes, it has to be heard on merits and it has to be remanded. That's why I said it could be disposed of. With that understanding, it is posted. Any day, convenient to them. I have no objection. Date may be fixed.
Then the counsel, Shri Y.K. Narayan Sharma is present before the court. Learned counsel, Jayant Rao Shinde. You are for R2. R1 and 2 is present. Who appears for impleading?
2 is impleading. R2 is impleaded.
You are appearing for 1 and 2, both?
Both.
Stop. Learned counsel for the respondent seeks time. And list this matter next week.
Could be date, my lord.
Next week.
And the list of citations I have given furnished.
ಅದು ಕೊಟ್ಟಿದ್ದಾರೆ ಅವ್ರ copy. You can find it in the registry. Yes, Shri Prasad. So this appeal by the plaintiff. The suit for injunction only. Dismissed. Ah. What you filed a counterclaim? Your counterclaim is allowed. Yes. So the written statement, schedule premise, suit property, and the plain schedule are same.
Now they are finding application. I think we not to build the packets. The build is done. Right law position. And I think easily not get us money.
No, but here, is there any order here?
No, this is not the first one.
And you go ahead and do what you want. He's not here. Because as this is coming for the first time. There is no representation on behalf of appellant. Learned counsel Sri Shiv Prasad Shantangowd is present before the court for the respondent defendant. Relist this matter after 2 weeks. You can go ahead and do what you want. Yes, Nishi. IA1. ನಿಮ್ಗೆ ಸಿಕ್ಕಿಲ್ಲ. What is the specific performance? Who are you? You are appearing for whom? One minute. Your respondent number 5 plaintiff. You filed the suit for specific performance against. So you have purchased the property agreement of sale from defendant 1 and 2. Okay. So during the pendency of the suit, defendant 1 and 2 have sold it to defendant number. Not to alienate. So during the pendency of the interim order, you have purchased.
26/3/2004.
26.
Right, exhibit D.
Admittedly, after filing of the suit, you have purchased. So you had the interim order on the date of filing. All right. Now, what do you want to argue? You want to file. What is the application you are now seeking? State. Have you filed execution? It's not filed. What is the total sale consideration? Balance 5 lakhs to be paid.
Witnesses are not examined at all.
All right, you file your objections. Padil Antaral. Learned counsel for the appellant is present before the court, so also learned counsel for respondent number 5. Stop. Learned counsel for the respondent number 5 submits that he has not initiated execution proceedings. To execute the judgment and decree of the impugned judgment and decree, which is challenged herein. Stop. Same submission is placed on record. Relist this matter after 2 weeks for objections to IA number 1, if any. He is not filed, that is recorded.
Final hearing, number 35.
Lords, I appear for the respondents, my lord.
Yes.
Respondent number 3.
Yes, you are ready?
No, my lords, may I seek 2 weeks' time, my lords.
You are ready. You are also not ready. ಇಬ್ಬರೇ ಬಂದು ನಿಂತ್ಕೊಂಡಿದಾರ, ನಾವು ಕೇಳಬೇಕು ರೆಡಿನಾ ಇಲ್ಲ ಅಂತ. You are the plaintiff or defendant? Your suit came to be dismissed. When will you get ready? No, when will you get ready to argue? What, madam? Where is Mr. Chalapati?
Any date after 2 weeks may be given, my lords. Senior will not argue.
Understanding ಇದೆ ಇಬ್ಬರಿಗೂ ನಿಮಗೆ. ಇವರು 2 weeks ಅಂತಾರ, or any day after 2 weeks ಅಂತ ನೀವ್ ಹೇಳ್ತೀರಾ. 2017 matter, both of you agree also, court is not going to grant you time. After 1 week. ಏನಿದೆ ಅದರಲ್ಲಿ? You must have already got ready. Your suit is for possession based on title. What is the defense of defendant? So there's a dispute with regard to identity. Agricultural land. Is it agricultural land? All right.
We made a request to the guy for so amount of point, that's where the Supreme Court. There's an issue to the location of the property that has been between the farmer. Cannot decide the location of the property.
On what basis the court has dismissed? When the court itself was not sure about the identity. Oh, you have gone to court. You are the best master of your case. You have to produce the best evidence. Heard, Leonard Counsel Sri Giridhar SV for the appellant is present before the court. Learned Counsel Srimati or Kumari.
Kumari Anaga Jayaprakash.
Kumari Anaga Jayaprakash is present through video conference for conferencing for respondent number 3. Both the learned counsel seek time to get ready in the matter. Release this matter after 2 weeks. Partition suit. Likelihood of settlement. Very good. Do it. What is your name? Huh? Kishore. What is your name? You are appearing for BL Acharya. He has filed NOC Vakala. Now, all right. Now, Vijay Krishna Bhatt, is he still there on record? Our NOC nimag bandidya. So his name can be deleted. Where is Pundika Ishwar Bhatt? Learned Counsel Shri. What is your name? Kishore BK. Appearing for the appellate. You have filed Vakala? No. Your BL Acharya is now senior, designated senior counsel. Kishore BK undertakes to file Vakalat on behalf of the appellant. Full stop. Registry to show his name in the cost list. Is permitted to file Vakalat within 2 weeks. In view of counsel Sri BL Acharya having been designated. You have not filed Vakalat. All right, then we'll have it next week. When do you want it? All right. Learned counsel so-and-so submits that there's a possibility of an amicable settlement between the parties. He requests time. Hence, release this matter after 2 weeks to report settlement, if any. Where is Archana? Correct. Formally, it was posted today. So nothing more to add. Still. Later judgment. Which para? Yes. He says you yourself raised cloud.
What is independent and stated. It is fine to come and be here. I can't get
The suit schedule property is a vacant site. Watchman. Oh, that lady standing electricity bill and all you have produced.
My lords,
Ah.
my lords, I'm sorry, I'm held up in the other, your lordship may kindly have it at 2:30, my lords. I'll come over physically.
What remains? You are welcome to come at 2:30, but you have argued extensively, madam.
Yes.
The arguments madake.
Illa ashtene. Everything is done, my lords. I thought I'll just come physically to attend. At 2:30, if my learned friend is okay with it.
2:30. He has relied on one judgment. You can collect it from him. 2:30 will.
Much obliged, my lords.
All right. Nothing more, I think, Mr. Janardhan. I think both of you have extensively argued. She has also tried. No, there are several judgments post Justice Ravindran's judgment in Buchi Reddy's case.
Much obliged, my lords.
Yes, 2:30, madam.
Much obliged.
Badrinath, yesterday's matter, Allah? You're going to go by paper book only, right? So you have purchased in 2000, yes, purchased in 2001 and 2013, 2003. Page. That is admitted. That's not disputed by him. Which is that document? Which is that document? Correct. That is or is there any earlier document? Your vendor's document? No. So your exhibit P1 alle irbekadu. I remember seeing that in the very first paragraph. Hmm. 73 ಅಲ್ಲಿ. So totally how much? Correct. That's the total amount of extent of land. Survey number 57/1 is a property. They were You purchased to an extent of 20 guntas. So before you purchased 20 guntas, it was changed to 57(1)(a). What is this 2 guntas of land, 57(1)(b)? Land measuring 1 acre 10 guntas belonging to Srimati Gauramma. Remaining 2 guntas yardu. If it was under, then it should have joined as if it was with Gauramma, then there was no need of and. Gauramma ge 1 acre 10 guntas belonging to Gauramma. And these 2 guntas became 57(1)(b). So your vendors had 2 acres 6 guntas. PDA took possession.
They have been between 1 acre, 3 acres. That I have been purchased 20. Six quotas have been told to 1 possession, 36 crore.
So what is sold to you is on the northern portion of it. Yes.
I can create a 16 this time, I have been purchased to do. 1 acre 30. Thank you.
All right. So your vendor's name is Krishna Reddy, alla? Pilla Reddy. Yes. Tell the document. Have you produced and marked it? In your sale deed. How much is sold? Tell the page.
They have been rated only 60 gunas of land. 60 gunas they had rated. They had partitioned the property in respect of 33 gunas, next to each other.
Out of 2 acres, 6 guntas, 20 guntas are purchased by you.
30 gunas purchased.
According to you, 33 guntas is acquired by BDA. So what is the amount of land remaining?
And remaining there is 16 gunas after selling to the village.
You are not disputing this 33 guntas acquired by BDA. Total? Sorry? 1986. Okay. Anyway, the fact of 33 guntas being acquired by BDA is admitted. Whether it is from 3 acres or 2 acres, that we'll see. That also will be borne by records.
They had rated only 60 gunas. And the big deal for partition deed. That is in respect of 33. Excess land. All the partition. Not
What they partitioned?
they have rated only 60 gunas. They have partitioned the two children from 33 gunas.
So only 16 guntas was available for partition, according to you. So where is that bone? Where is page?
One feet is equal to 1. Half a mile.
Page number 69. ಓದಿ ಅದರಲ್ಲಿ ಯಾವ್ದ್ರಲ್ಲಿ no now you're disputing this. You have to chronologically come as to how much is the portion of the property after selling to you BDA, what remained. Now where is that document after selling 20 guntas and 33 guntas of 2 acres? Correct, sir. That is not disputed. 86 ali acquisition I. What remained after that and what was sold to anybody else, it was sold. Where is that? Is that, are you admitting that? All right. Okay. Yes.
1 acre, 2 acres, that is 1 acre 6 acres. 33 acres minus 1 acre 13. 1 acre 13 acres minus 14.
Out of 2 acres 6 guntas, if you minus 33 guntas, just birthday. One acre. So minus 20. 1 acre 13 guntas minus 20. Just one. 33 guntas. Huh? That's why I said the 2 acres 6 guntas minus 33 guntas of PD acquisition. Yes, after that, you have purchased 20 guntas. Minus that, how much remains? $1.13. So 1.13 guntas will be the balance that is left with your vendor.
Is that minus?
Other state. How much remains? So balance left with the vendor will be 33 guntas.
33 they have got 6 guntas to 1 place. Go to 27.
$27. Yes.
Ready, and every equal parties in the property.
So that is D4. So these are your vendors. Pilla Reddy, Krishna Reddy and all right. So how much they have partitioned?
There are two parties, there are three parties in the 30.
Usually they are D4 only. Read it. So that is correct then. 27 should be there.
Where CMA has been regularity right? It is not. Why has been given 6+1. Where personality and utility got 13.
13 guntas each, 26. Our guess ಬರ್ತದೆ?
Okay, 6+1.
26 plus 6.
Should be partition date should be in respect of 27. That date that will be 30. So in exhibit D6. One.
That's what is D6? So that is at 6.1 plus another one.
After the partition date, they have been
From?
the partition.
No, who has purchased? Who's that? So D6 is the same deed, you know? Dated?
D6 and D7 are same.
That is how he claims title.
Just one year.
Lokesh Reddy. So Lokesh Reddy purchases 29/11/2001 D6 is to 1 gunta. 1 gunta. So which is that other one is D7 and D8. D7 and D8. Correct. D7 he purchases one. The other one is 2003. ಅದನ್ನೇ ಹೇಳ್ದ. D6 and 7 is 2001. D8 is 2003. 66 into ಏನದು? Square feet. 66 into 7. Divide D8. But D7 he gets 1 gunta.
6 and 7, 1 gunta each.
So D8.
D8, 66 into 7.
You know, 66 into 7 and the rest. 462 square feet. So that is less than 1 gunta, half of 1 gunta. So he gets 2.5 guntas, not 3 guntas.
During the pregnancy of dispute, where the entry matter granted to on one of the date where the entry matter has been not extended. Thereafter, could not get the entry matter. They have given undertaking before the court. They will not undertaking. Judgment before the trial court judgment before the reasoning it has been written. After the reasoning, it is not discussion about it. Two, where the court commissioner has to point out what is the enforcement portion in respect of 2.5 conduct has been not again. Commissioner report says that if only his code number is not enough, it cannot be identified. One more. They have to respect of exhibit D4 parties exhibit 63 and respect of 33 members. 27 voters have been respect of 33 members. To defeat merit, they have executed the partition.
What is the date of that partition?
1/3/2001.
Yes.
In respect of the slope to the simulation, it has been in front of my appeal practice.
Page 294. Yeah.
In respect of 6 it has been to the
No, what is this judgment? Is it? You are where you have stated. No, what do you want to say? What do you want to establish in 294 page?
Partition. It says they have done the partition. Person has to convey the data. Party has a data to the person. It's not exceeded that individual. Then the commissioner's report.
Second defendant, Yaro? Moni Reddy. He is also his vendor. Defendant, first defendant's vendor. Oh, you are page number 294D. There is a sale deed of Suresh, is what you are saying. That he has purchased from whom? From second defendant. 2.5 quintas. So he has purchased
property which they had been sold to. Okay.
Location. Lakshmamma ಅಂತ ಇದೆ.
The properties have been allotted to the Sally dated 12/2/2006 in favor of Lakshmana executed by special security holder of the second different personality able to personality GP. Just Suresh. Suresh has been switched.
Correct. Suresh is acting as a GP holder of second defendant. So second defendant has sold the property in favor of Lakshmamma.
They are not made expiry and family member of the parties. And the partition deed properties have been fallen to GMA personality. Where the GMA property has been purchased by location in respect of 1 crore. In respect of Krishnaredi's property, 1 crore is active. In respect of Reddy's property, purchase 7 into 2.5 crore. Where this is in respect of 2.5 crore. Where we look at the commissioner's report sketching is there. This sketching has been mentioned only to an extent of 17.5 crore. 2.5 crore which has been not of identified. What is the portion of the encroachment?
So the 2.5 kuntas according to you is the encroached portion, which is not described by the commissioner as to where it stands and whom it belongs.
Where the property acquired, they have been not disclosed.
Whether BD is a party.
Acquisition of property it is admitted.
Now, this 2.5 guntas of property which was acquired by this Lakshmamma, where is that property located? Northern side, southern side, which side? Whether it is coming within that area of property which you are saying is encroached by him? The encroached portion is measuring?
2.5.
Correct. One. Ah, 117. 20 guntas.
In respect of location when you purchase the property, see half portion you want to apply. Let's see half portion it should be divided. See dollar like then it will be the exact sale property and properties in this
E C D E F idiyalla. That is 2.5 guntas according to you. That is the encroached portion. So now you are saying that half gunta is purchased by idರಲ್ಲಿ CDEF ಅಲ್ಲಿ. Correct. D8. You're talking about the 2003 sale deed. 66 into 6. 66 into 6. 462. ಇದು ಎಷ್ಟು ಬರುತ್ತೆ?
Then it comes to 160 square. FCDE, that question should be 1 square it will be.
1 square.
So what will come to conclusion that where I have not been produced the revenues. I mean, if 1 page or 116. So the inroad form with the property which I have, but if the credit in the upstage, that can add everything.
ಇಲ್ಲಿ 116 ಅಲ್ಲಿ
Respect of the declaration had the respect of the nation they had not only in respect of our part of the declaration.
Your permanent injunction is allowed of your property. Now, with regard to encroachment, your declaration is dismissed. Yes.
After the compound was, they would not be able to. But that aspect has to, court has to look into that. The court will come to this, there is a compound was, for encroachment.
This is what you have produced is a rough sketch prepared by you. Where is your sketch of property purchased by you? Only sale deed. Sale deed. So what as per if you go by this 107, where is that? It is a commissioner report. 222.
I do only respect something around. Part 1.
Part 1, 17.46 kuntas. Part 2, 2.53 kuntas. Total 20. All right. This is the commissioner's sketch.
First question you have to specify and you have to mention it.
No, both of you have no objection to this sketch. You have not filed any objections disputing this sketch. So both of you are agreeing to this commissioner sketch. Alva?
The commissioner should have done his duty to identify respect of the name of my instructions is there.
By the court? By the court or by the part you? What have you said? To identify. So the part B, part 2, 2.53 andre it is more than 3 guntas. Huh? ಇಲ್ಲ ಇಲ್ಲಿ 17.46 ಅಂತಾರೆ 2.53 ಅಂತ ಪಾರ್ಟ್ 2
2.23. Part 1, 17.4.
Correct. So 2.53 guntas. Less than 3 guntas.
Survey, inspect, initiative property, identify the building, initiative property, initiative. Other existing initiative property. And measure all the sites of the initiative property. Take the photograph. Regarding enforcement process that we want.
So in your schedule of your sale deed, what is the property mentioned towards the south?
So the 57 property.
Remaining portion of 57/18. Your vendors. That is Pilla Reddy, Krishna Reddy. According to you, where is this defendant Lokesh Reddy?
To the property.
North ಗೆ opposite ಆಯ್ತಲ್ಲ. ಹೆಂಗೆ?
Remaining portion of 57 property that proceed property south there.
No. The schedule of your boundaries to your property. South ಗಿರೋದು is this encroachment area. In the schedule of your property, south of your property belongs to the remaining portion of your vendor. So where is he?
That is the, is our government, where dictionary is saying 1.5%.
So your, no, in scheduled property south is the remaining portion of your vendor, not he, not defendant.
They are dependent. They are only the dependents are being used.
So they have purchased or what?
They are showing that they have parties in the property and they have been.
Defendant. All right. That's all. Your argument you complete. Continue. We'll continue afternoon. ಯಾವುದು? 39. You're not ready. ಎಲ್ಲಿ ನಂದೀಶ್? ಏನು family members? Possession. Here, what is the dispute?
Based on the partition deed, we get between Owen's husband. Where the is one of the property. The court has accepted the partition deed and.
What is your relationship?
So it's my sister, I am the sister-in-law. The point. And their children, brothers.
You did not go for mediation? No possibility? Don't make such submissions. It doesn't matter whether he is a gunman or a presiding officer or court officer. In a gunman andre which gunman? Huh? Assigned to me. He's working as a staff in the court. Assigned to one of the honorable judges. That doesn't matter. He's not attached to me personally. All right. Recording. The counsel for the appellant seeks for some time. Release this matter. When you are next week? Next week.
Serial number 42, Your Lordship. 42, the last matter on the list. Personally, not well. I have some shoulder issue. Kindly have it about 10 days later.
VB Shivkumar client idhar aur bartarante.
VB Shivkumar is not appearing in that matter. I think
Nagendra Naik.
Couple of counsels have changed on the other side.
Nagendra Naik is here. What is this matter?
Suit is one for partition and separate possession. In fact, on the last occasion we have submitted before Your Lordship, there is another suit, OS 2736 of 2001, which is a suit filed by one K. Venkatesh and K. Munraju. And an appeal is pending pertaining to the very subject matter.
You are not well, Mr. Banaprasad?
Yes.
All right, we'll consider it. Let his counsel come. The parties are here.
Yes.
I'll grant you some time. Let him come at 2:30.
Yes. My colleague will appear. Kindly excuse
me. No problem. You can tell your colleagues to.
Yes.
ಆಮೇಲೆ ಮಾಡ್ತೀರಿ 2 ವರ್ಷ ಮೇಲೆ ಆಮೇಲೆ ಮಾಡ್ತೀರಿ ದಾನ ಮಾಡ್ತೀರಿ.
Court officer. Court officer. Court officer.
ಹೇಳಿ ಸರ್.
Audible ಇದೆ ಮೇಡಮ್.
ಇದೆ ಸರ್.
ಧಾರವಾಡ ಅಂತ. ಹಲೋ.
ಆಡಿಬಲ್ ಇದೀರಾ ಸರ್? ಕೇಳಿಸ್ತಾ ಇದೆ, ಕೇಳಿಸ್ತಾ ಇದೆ. ಧಾರವಾಡ ಬೆಂಚ್ನವ್ರಲ್ವಾ?
ಹೌದೌದು.
ಹಾ ಸರ್.
ಮೇಡಮ್ ಫಸ್ಟ್ ಧಾರವಾಡ ಬೆಂಚ್ ಅಂತಾರ?
ಸರ್ ಹೌದು ಸರ್.
ಹಾ ಸರಿ.
Total 100.
Sir, MSP yaar sir. Sir, MSP yaar, please mute ಮಾಡಿ. ಆಡ್ಬೋದು. ತಾವು ಗಲಾಟೆ ಮಾಡ್ತಾ ಇದೀವಿ ಅಂತ ಅವ್ರಿಗೆ ಗೊತ್ತಾಗುತ್ತೆ. Yes, I also got the same question. I
intention is very clear that they should get their pay. Because why?
Matter pertains to Harvard bench. Harvard bench matter, pronouncement of orders, seal number 1, Avinash Pankar.
Sarikon.
Please.
Where is Mahesh Wadiyar?
Please.
Where is Mahesh Wadiyar?
Mahesh Wadiyar is also there in video.
Yes, sir.
Ah, you are not seen.
I'm appearing.
All right. You are able to hear.
Please.
Having considered all Mr. Dharikond and Mahesh Wadiyar, your submissions and arguments, therefore, it is seen from any angle, the petitioners have not made out any good valid ground to show their bona fides that they had prosecuted the matter diligently to consider a case similar to that of the reinstated workmen. Admittedly, petitioners had not adduced evidence, neither produced material before the CGIT for consideration of the claim. So also it is true that no order came to be passed in favor of the petitioners by the CGIT. Hence, petitioners were not beneficiaries of any order of the CGIT, having not shown any cogent bona fide reasons for having brooked enormous delay in approaching this court. They would be not entitled for any relief as they have not shown reasonable ground to condone the bar of limitation and laches encountered in the present case. Though the similarly placed workmen were granted relief by CGIT, who had diligently participated and adduced evidence, petitioners would not be entitled to the same relief despite similarly being placed on the ground of delay and laches. Allowing the petition would amount to condoning the bar of limitation, an enormous amount of delay proof gets obliterated and ignored. As stated earlier, this court is not inclined to give benefit to the petitioners for the act of trying to revive a stale dead issue by way of making representations to the respondent management, which is self-created representation syndrome, to revive a dead stale claim, which is discussed in detail by the Honorable Apex Court in the case of CH-21. Accordingly, I pass the following order. Petition is dismissed, no costs. Yes, sir. Janardhan, where is Janardhan? All right. Yes, Madam Archana. Yes. You have extensively argued. Ah. Page number? What is the difference? No, the schedule is, what is the schedule? Read the schedule. Yeah. Bodhi. Hmm. Hmm. At 19. Howದು? How? He says he is the owner of all that piece and parcel of site number 119.
Entire site number.
In one entire. That's his case. That is what he says in para 3. Plaintiff is absolute owner, possession, enjoyment, immovable property, portion. Your property of northern portion of site number 119. Northern portion of site number 119. Oh, this is your. So what is his? There is a plain schedule. Read that. What is yours? 376 square feet. The schedule is different. Halichandra village care from Hogli. All right, but both are looking different. That is your argument? Correct. No, that is dismissed. That is dismissed for non-prosecution.
section A, what we are saying, the portion.
You have to go on before the court and say, you have not even gone, you are creating a cloud on his title by his own statement. No. That is not permission. Yes, you have done your job effectively. Anyway, this was posted today formally because in the other matter you had not taken notice and you had not appointed amicus. So we'll say heard on both sides. Recording. Heard the learned counsel Sri Janardhan G for the appellant, both the matters, and the learned counsel Srimati Archana KM, amicus on behalf of respondent number 1 and 2. In detail. Matters reserved for judgment. Yes.
Subsequently, they have amended this line. They incorporated para 7A and 7B. In 2011, 2007, and they sought for amendment of this line in 2011 by incorporating 7A and B. And in this schedule, you know, my kindly, my lord, yes, schedule.
Hindi?
Yes, schedule property. You have 10 schedule page 13.
Yes.
Towards south at page 14.
Towards south.
Remaining property of survey number 57/1. Now, my lord may kindly come to.
So if we analyze the sketch, it is just below. Below that whole property which he has purchased, 20 guntas, Karnataka portion is the south. According to him, is the remaining portion of his own vendor.
So, own vendor is his schedule. Now, I request my lord to compare they have a 6. It is not This purpose of submitted themselves is this actual practicality, the dependence of property situated towards certain kind of other side. All of a sudden, the content by 2007, along with the support of scholars, came here. And they illegal attempt to come towards southern side of the plaintiff, and thereby made illegal attempt to by the plaintiff could not be able to resist the illegal acts of the defendants for the time being. The defendants who left this part of proclamation that they have since their attempt, they would put the plaintiffs to the of enforcement scheduled property. See, this comprehension accordingly is available in
2007, huh?
on the date of
2007 is a suit. Yes.
Now, When there is an apprehension of the plan towards south, defendants are trying to enforce upon the property. That means to say that he himself could have been sought particular reason for the entire reason property for 20 hectares. And he says only towards southern side, the defendants are trying to enforce upon his property.
Yeah.
That means to say there is a dispute which arises with respect to the property that he has not sought for such a declaration.
Why he should seek for declaration?
For the declaration, because southern side, what is the extent available to him, that we have to take. And towards southern side, what is the extent available in 57/1A? That he has not stated.
What is the schedule of the plaint?
Schedule of the plaint is 20 quintals of A-schedule property. Converted for the purpose of non-agricultural use.
So originally when he filed the plaint, A and B schedule both were there or only A?
No, it is not A. It is only A.
Correct.
It is not served for B.
Correct.
Therefore, I am saying that the amendments in para 6 clearly establishes he himself is definite that there is an encroachment.
No.
Para 6.
No. Where is encroachment?
Yes, they would definitely put a consent and enforcing the suitable property.
There is a difference between encroachment and apprehension of encroachment. His case is in para 6 that they would attempt, made illegal attempt to put illegal construction and made illegal attempt to disturb peaceful possession of the suitable property. Plaintiff could able to resist illegal act. Defendant left the spot. It is not his case that day only you encroached.
No, what I said before my argument. In para 6, he says towards southern side, defendant's property is there. In para 6, basically, line 3. In schedule, he did not show. It is the the action defendant whose property is situated to southern side. So he says southern side property of defendants are there. In the schedule, he says remaining property survey number 57/1A. He did not say property of the defendant. And in further paragraph, they say that there is a trying to enforce the property. Now, subsequent to that, para 7, A and B have to be implemented.
That is after amendment.
After amendment. Now my land can come. Para 7B. I will read 7A. When the further submit that our filing the above, the Honorable Court of Peace to grant an order of the practice court the effect that the both party are directed not to put up construction. The said order was extended from time to time. It is not to put up construction and status quo. Later, the plaintiff was unable to get the said interim order extended by law, taking undue advantage of non-extension of part of the defendant order construction by imposing upon the most of property towards its southern side by illegally and unlawfully. The plaintiff immediately filed an application seeking for extension of interim order. The defendant have filed untenable objection to the application. However, the Honorable Court after considering the undertaking of the defendant that they allowed the victim to go consulted property. In the event, the Honorable Court considered that the defendants have enforced upon the court of suitable property ordered not to put up any construction towards the northern side of the alleged building of the defendants. They made a purpose of it. The defendants taking undue advantage of the non-extension of the including model as well as the cover order and 84218 and the fourth have constructed a building by enclosing the middle property towards the southern side, facing towards eastward at 120 feet, after 24 feet, and towards eastern side 20 feet, towards western side subsequent to the filing of the above two case illegally, unauthorized. Since the construction is subsequent to the filing of the above case, and in view of the undertaking to the defendants of the above case, the defendants are able to pull down the sentence and not on this. Now, in the event the Honorable Court comes to a conclusion that the enforced court belongs to the plaintiff. Therefore, he is not specific that there is an enforcement. He says, leaving to the discretion of the court in the event is not the court enforcement. At this point, I say only 3 points before we learn. No pleading regarding the 2 schedules, A and B, how it has been introduced. Nowhere in the brief it is stated why A was stated for the 25th of Supplement and why B has been stated. And secondly, whenever this is seeking for declaration, there must be pleading. That this court to be clear that I am the owner of this scheduled property, which is a part of a scheduled property. Therefore, I am entitled to. Thirdly, they introduce.
Kelly, read one is read prayer, sir.
What I say, reading I am saying, nowhere in the plain they say that they are the owners in respect of A scheduled property. The B scheduled property will be approached, declare that we are also owner of B scheduled property.
Whether as he sought for declaration of B scheduled property to be his ownership.
That is not he seeks for prayer.
Correct.
Yes.
Kelidara.
Prayer Kelidara. Pleading shall be not
Yakilla pleading sali. It is his case that he is owner of B scheduled property.
Nowhere it is stated. What I say, can I 7 years my land is
Para 4 ಅಲ್ಲಿ ಇದೆಯಲ್ರಿ. Even para 3 he says he is an absolute owner.
He's absolute owner of B scheduled property.
What is B scheduled property?
B scheduled property, he must state after the amendment that B scheduled property is part of A scheduled property. Therefore, declare that amendment is not.
ಹೇಳಿದಾರಲ್ಲ. 7A ಅಲ್ಲಿ ಇದೆ. 7A after the amendment got filed. Amendment has come into existence because during the pendency of the suit, you have encroached. So what he did, he sought for amendment which came to be allowed. 7A is the amended pleading. In 7A, he very clearly states that during the pendency of the suit, you have encroached. Now that is why he sought for this declaratory relief.
Therefore, nowhere it stated he seeks the declaration for B scheduled property.
Even if he doesn't say in the pleadings, cause of action is what?
The cause of action according to him is 2007.
Or what is the meaning of cause of action?
Bundle of facts.
It's a bundle of facts which cannot only distinctly say one line or one para.
See, 2007. He did not say anything about B scheduled property.
There was no need for him to say about B schedule in 2007, sir. Avaga, he was apprehending. You are making attempts with all your implements, sir. That is his case.
No, my lord, kindly come to my intersection.
You are Manjunath, Allah? Rajana Shetty. Yes, sir.
I have pleaded in my written statement regarding my stay at Para 3, A, B, C. The plea of the defendant. Para 3, A, B. Now I will request my lord to come to page 43. Yes.
Is it in the statement?
The statement 7/7/2007.
Yes.
Yeah, it is stated by the defendant that the plaintiff's property consists of a compound and it has nothing to do with the property of the defendant. File this compound to the case. On 7/7/2007 itself, I have clearly stated there is a compound in and around the property. The plaintiff. Therefore, such an enforcement Of any portion does not.
So you're saying that the plaintiff has a compound
In and around his property.
of A scheduled property. So the question of you encroaching does not arise. After that initial written statement, did you file any amended?
Yes, cancel return statement page 35.
Other line ಹೇಳ್ತೀರಾ? Para 4 page. Yes, may read.
That I'm fighting so and so.
Yes.
Now they go down to the court of peace, that out of that is and both the parties are directed not to the said after later the plaintiff was unable to get the agreement for attended by both sides. Taking the unworkable towards the southern side, illegal and lawfully, the plaintiff immediately filed an application for attendance murder. The defendant filed an untenable objection to the same thing, then I said delay. Hereby denied and inter alia stated, my lord.
Yes.
The plaintiff uttering the falsehood and government is nothing but issue of life. The interim order granted by this court was not sought to be extended for the reason the compound of the plaintiff building was found in the channel, and in view of the court passing the interim order of both the parties to maintain status quo, the plaintiff could not put up the compound and thereby has not sought for extension of the interim order. And during the non-extension period of interim order, the plaintiff put up the compound towards the channel side, and thereafter completion of compound, the application to file for extension of interim order, just to stop the construction of the defendant building and to allow the defendant for it the plaintiff could not keep. Therefore, my lord, I specific that the compound was on the eastern side fallen down. Because of the status quo, he could not complete the compound wall. He did not sought for extension. Then he sought for extension of completion of compound wall.
Eastern wall.
Eastern wall.
Eastern side, this is on the southern side.
This is southern side, one side of the wall. Because the channel ಹೋಗ್ತಾ ಇತ್ತು, ಆ channel
ಸರಿ ಆ ಕಡೆ ಈಸ್ಟರ್ನ್ ಸೈಡ್ ಬಿದ್ದೋದ್ರೆ
status quo inter propagation property.
maybe that he can always see. How does the wall of the southern side get affected?
Because the
So the southern side of the wall was intact.
intact. Eastern side fallen to the channel. Because of the status quo, he could not accept because only up there. Then he did not start for extension of the interim order.
All right.
Therefore, may not consent to these pages, madam.
The channel side and the eastern side, huh?
Eastern side.
So now are you agreeing and admitting that the southern side of the wall of the plaintiff is still intact?
It is admitted by CW1 himself. I will not.
PW1 Auro.
Oh, yeah, admit after the company then.
Then you're also admitting?
Yes, my property is divided by the compound. Our compound cutting when our property.
In that A schedule property.
A schedule property. Our put the compound up there.
Correct. A schedule property is 20 guntas. Then where
Yes,
is
right, the compound.
all right? Now this suit, which is filed by him for declaration and possession and injunction is granted. If declaration and possession is granted, how are you affected?
Correct. So far as that is concerned, what he is seeking is demolish my construction view. What I am affected. Otherwise,
No. You are now admitting that A schedule property belongs to him. You are admitting that is 20 guntas. You are admitting there is a southern wall on his property. After that, your property begins. Injunction is granted. You are not challenged.
but it is not extended.
No. Permanent injunction is granted. You are not challenged. So injunction is granted to A schedule property. Only with regard to B schedule property of declaration and possession is rejected. Now, if you are admitting A schedule property belongs to him, 20 guntas belongs to him. There's a
I don't admit that 20 guntas. That's not my case. I clearly say my dad. I deny his ownership of I will demonstrate before my dad. Pursuant to the same thing, the understand of what is also. Because
you have not challenged the order.
I have not challenged the order.
There is an order now operating that is A schedule property permanent injunction in his favor.
Permanent injunction in his favor in respect of each person. I don't say that is possible.
No. You cannot interpret it the way you want.
No, I am not interpreting that.
You cannot interpret it. You cannot now. That is far out of sight. Now the question is, A schedule property is described. Suit is decreed with regard to his permanent injunction. Only declaration and possession it is rejected. A schedule property permanent injunction is 20 guntas, which is described in the schedule, which is also given by the commissioner's report. Other new challenge madilla. So what lies in your mouth now to challenge?
I am not. That's what I said. Declaration and possession what is our respect of A schedule property is unsustainable. If I am able to demonstrate before my dad.
But
then
all right.
Pursuant to the pleadings, my lord, issues of them may not be kindly come to face part of it.
But have you stated in your written statement that this property does not belong to him?
Yes, my lord, denied it.
Elli there.
Traversing the government supply, with regard to traversing, that the plaintiff is the observed owner of the point and a as well. And therefore, that the plaintiff purchases the property from the Israel who is government partner of the property. Also, written article and pass and the plaintiff.
Page 16 only.
Page 16 is my statement.
Correct. Which para you are reading?
Para 2.
With regard to para 3.
The plaintiff is the observed owner in person enjoyment of 50,000 of 1 year of is hereby denied as false and plaintiff that the plaintiff purchased the single property from Israel and others who is bona fide purchaser, the Karnataka came to his name, and so also it affected an RTC is hereby denied as false and the plaintiff for the same.
HOD H.
The schedule given thereon is incorrect. For the purpose of argument, does not consider the stated with reference to the the defendants are trying to ensure the property of the plaintiff, but the schedule property is so detailed property of the petitioner for 1 year, not so the property of the defendant. It's clearly established the plaintiff is not so further of this case, and he wanted to lay claim upon the property.
Para 3.
Para 3, as the defendant is the observed owner in question enjoyment of the property, I think 40 plus 41 or 2 plus 61, 65, 68, which is bounded on the east by Mudradis property, west by road, north by Naga's property, south by Ramas property. The land there is 757 by total and the acre 16 out of the 11 hectares around and it belongs to nominated and based on the given to be succeeded to Mudradis, Krishna and others, and accordingly to their bodies, they have shown their respective shares to the property purpose of the victim size and also that of extent to agricultural property. The defendant has purchased the property under 1 foot of land and 29 on religious entity from Krishna and his children. And 29 until 1 gunta, which is registered as document from Yellow Capitality. And that is how 2003 within an effect of each big number of project, which is registered as document number. Also, from 100 years is given. The opposite extent, now out of this one, the 1 year, there is go to and the above coverage is still adjusted with 1 unit and 14 measuring participate. Pursuant to the appeals of the above property, the
So
mutation.
what is the total measurement of your property?
The total measurement of my property is 40 plus 41 over 2, 64 plus 65 over 2.
Just right. Just right. So what is that? Sorry.
So 2 guttas, 450 by 3.
Where is the schedule to this?
I have done it because of 3A.
Read that. So if you have purchased the property, which is southern side of the property bought by him under A schedule property, your property should reflect, if it is adjacent to his boundary, northern side of your property should show his property.
Then I was property.
Order. So that means your property is next to his property. That you are agreeing.
But I did also serve.
So admittedly, just below his property, southern side is your property, measuring 2 guntas and 400 square feet. Yes. Yes. Yes, sir.
Page 43 is the issue favor the report on 5/4/2003. Page 43.
40.
These are 5/4/2008. There is a plaintiff proof that is the lawful enjoyment of the property also. There is a plaintiff proof that is in the present. There is a plaintiff is attained of part. Additional issue and 26 days. Does the plaintiff prove is one of the forms being on property or valid? Does the plaintiff prove that alleged enforcement by defendant for freedom property? Does the plaintiff is detained for illegal operation for so these three additional issues of your constitutional. Now the issue. Now the plaintiff has entered in the order. That is available on page 45.
Yes, sir. Yes.
Now, page 51, my kind of exam is in page
51.
51. Right. The last 2 lines.
You can read from I humbly submit.
I always submit the defendant take undue advantage of as a other order they make as opposed to the accepted within the property, property to a southern side, there is a east to west control not the eastern side, 24 feet and 20 feet, subsequently finding the about it. Now, I stop at this and I request my last something even stating. The relevant course in which I Page 750 million.
I'm having 7. Sale deed.
Survey number 57A. Measuring 20 Gunda. Middle of the barrel. Whereas the vendor
Yes, 57/1 measuring 20 guntas.
20 Gunda. East to west on the northern side. Now the measurement is important. Relevant is on southern side 108.
108. Northern side 150.
150.
Southern side 108.
I have nothing to do with the northern side. Because it is only southern side 108. Now my lord may come to the evidence part only. He says that the encroachment of 127 feet on this. That's what he says in the exam. East to west 127 feet and north to south 167. There are 8 page 51 from the exam.
Page 51.
51.
Encroaching upon social property towards
Southern
southern
side
side,
east to west 127 feet.
measuring east to west 127 feet.
Now, according to said it only, he got southern side only 108 feet.
Southern side 108 feet.
108 feet. You put your picture.
427 from where to where? East to west.
Even to that person also.
See, southern side is this.
Yes, madam. No,
East to west will be from east to west.
Therefore,
So southern side encroachment made by you is not 127, according to him. It must be some 20 or 24.
No, 127 feet. That's what I specifically say. Therefore, I request my lord to come to 170. So upstate the upper.
Now, what you read, para number 8 of page 51 is whose statement is that?
It is PW1.
Page 51.
Page 51.
PW1. All right. So that one says from east to west it is 127 feet.
Yes, madam.
North to south, eastern side is 24 feet.
Now, my lord can come to 170 and upstate.
100
117. C, D, E, F, my lord. Towards east to west, 127 feet. Towards the southern side, according to said is 108 feet only.
Towards southern side, according to sale deed?
108. 108 feet. Therefore, it cannot be 127 feet.
Sir, southern side is from A to E. Southern side is not talking about.
Southern side is east to west. That's one map also.
East to west is 127 feet.
Yes, madam. That is towards the southern side 108 feet. That's what I say. A to B is the east to west. North to south is from A to F.
This is the sketch produced by them? All right. In that 127. So you're drawing a difference that it cannot be 127. It has to be 108. Reply to that.
Number 1.
1 minute.
Now, page 116, the survey sketch produced by him and compared also made that. Towards southern side, 108 feet. That's the data made.
Kelly.
150 made it. The road on the ring road on made. 108 feet is that.
Where?
East to west 150 feet. Towards southern side, east to west 108 feet.
They're talking about 116. This is the one. This one. Other really the east to west.
ಈ ಈಸ್ಟ್ ವೆಸ್ಟ್ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು 108 ಫೀಟ್ ಈ ಲಫ್ ಸ್ಕೆಚ್ ಅನ್ನು ನಾವು ನೋಡಿದಾಗ ಅದನ್ನು 780 ಸೇಮ್ ಥಿಂಗ್ ಇಲ್ಲಿ ಸರ್ವೆ ಸ್ಕೆಚ್ 108 ಅಡಿ ಆಗಿದೆ
108 ಅದು 198
108 ಎಲ್ಲಾನು ಕೈಲಿ ಕಲಿಸ್ತೀವಿ 108
ಎಲ್ಲಿದೆ ಒರಿಜಿನಲ್ ಕೊಡಿ
PPP 14
so that is 57/1A 108 feet adu all right P14
This two tallies with the measurement showing the H51 also. Authenticated plan produced by them.
but that is not straight line, it's going up.
After formation of the ring road, it comes like that.
Correct.
The entire property has been shown.
Southern side maybe 108, but as it goes up it may increase because it is on a diagonally.
That's what, see, this sketch is put on the entire survey number 57,000. 57 bar A1 by 1A is the plaintiff who got the survey and who made that.
Correct sir, southern side il 108 andre northern side ಅಲ್ಲಿ ಎಷ್ಟಿದೆ
150.
correct ಅದನ್ನೇ ಹೇಳ್ತಾ ಇರೋದು.
That tallies is changed in the pattern.
If the property is rectangular in shape, then it cannot differ. It ಕೆಳಗೆ 108 ಇದ್ರೆ ಮೇಲೂ 108 ಇರಬೇಕು. If the property is diagonal, if it is diagonal, then what is bottom here need not be the same here because it goes on increasing. Yes.
Now, in the P1, the measurement of southern side is shown as 108. In the examination sheet also is at 108. And the rough sketch produced by him, along with the authenticated sketch with P14 also speaks 108. No, Mela. He has produced the document, Mela. At page 54, my kindly see. It is also reflected in the judgment.
Page 54. What is that?
In examination sheet, he has produced the documents. I have signed the affidavit. The documents now shown are the litigation and register extract, conversion order, notice issued by the deputy commissioner, 7 RTC extract, incumbent certificate, taxpayer receipt, of sketch. That is the every P14. These documents are marked as the P1 to P14. No, madam. I request my lord to take the document conversion order at page 6 and 90. ಬೆಂಗಳೂರು ಜಿಲ್ಲೆ ಬೆಂಗಳೂರು ದಕ್ಷಿಣ ತಾಲೂಕು ಮತ್ತು ರೋಡ್ ಜೀವ ವಿಕ್ರಯ 57 ವ್ಯವಸಾಯ ವ್ಯವಸಾಯಿಗಳು ವಾಸದ ಉದ್ದೇಶಕ್ಕಾಗಿ ಭೂ ಬರುವಂತದೆ ಇವು ನಾಲ್ಕು So I request my lord to come. Page 96, last quote. ಇತರೆ ಅವಶ್ಯವಾದ ರಸ್ತೆ ಜಾಗ ರಸ್ತೆ ಮಾಧ್ಯಮ ಖಾಲಿ ಜಾಗ ಇತ್ಯಾದಿಗಳನ್ನು ಅಭಿವೃದ್ಧಿ ಮಂಡಳಿ ಸಿಎಂಸಿ ಗ್ರಾಮ ಅನುಮೋದಿತ ಬದಲಾವಣೆ ನಿರ್ದಿಷ್ಟಪಡಿಸಿದ ನಿಯಮಗಳ ರೀತಿ ಸಭೆ ಉದ್ದೇಶಕ್ಕಾಗಿ ಕಾಯ್ದಿರಿಸತಕ್ಕದ್ದು. ಈ ಜಮೀನಿಗೆ ತಾಕು ಕೋಟ್ ಕಲಾಪ್ ಜಮೀನಿದ್ದಲ್ಲಿ ಭೂ ಕಂದಾಯ 1964ರ ಕಾಲಂ 67ರಂತೆ ಸರ್ಕಾರ ಉದ್ದೇಶಕ್ಕಾಗಿ ಕಾಯ್ದಿರಿಸತಕ್ಕದ್ದು ಹಾಗೂ ಪ್ರಸ್ತುತ ಭೂ ಪರಿವರ್ತನೆಗೆ ಹೋಗ್ಬಿಟ್ಟಿನ 57/1ರಲ್ಲಿ 11 ಗುಂಟೆ ವಿಸ್ತೀರ್ಣ ಬಿ ಕರಾವಳಿಯಲ್ಲಿ ಬರುವ ಕಾರಣ ಇದನ್ನು ಸಾರ್ವಜನಿಕ ಉದ್ದೇಶಕ್ಕಾಗಿ ಮೀಸಲಿಸಲಾಗಿದೆ. Out of 20 quintas, 11 quintas are reserved for the purpose of CA, civic committees.
ಸಾರ್ವಜನಿಕ
ಉದ್ದೇಶ for public purpose.
civic community ಅಂತೀರಾ? Civic community is
public purpose.
civic community is different from sarvajanika, that is public.
Public purpose.
I may not be too very conversant with Kannada, but I know what is sarvajanika and what is civic community. Sarvajanika purpose, public or use of public.
Public. ಈ ವಿಸ್ತೀರ್ಣದ ಮೇಲೆ ಅರ್ಜಿದಾರರಿಗೆ ಯಾವುದೇ ತಹಸೀಲ್ದಾರರು ಈ ಬಾಬತ್ತು ಆರ್ಟಿಸಿಯಲ್ಲಿ ಸ್ಪಷ್ಟವಾಗಿ ನಮೂದಿಸತಕ್ಕದ್ದು. That means to say this 11 quintas is reserved for the purpose of public that has to be notified in the RTC. Now my lord, time to see the RTC. Till 2004. Exhibit P5, procedural verification. Original articles.
RTC, no?
His name is not located in Exhibit P5 to P10. For the particular years, that is 2006 and 7. Exhibit P6.
This is for 57(1)A.
57(1)A.
Measuring.
2 acres 12 quintas.
All right.
Now, exhibit P567, 8, 9. His name did not find the place.
The
RTC.
All right.
Why such a modus operandi by the plaintiff is? There is a precondition in the construction order that there should be entry in the RTC. So far as 11 quintas are concerned, out of 20 quintas, this is how. Therefore, he would not take the entry of his name. Subsequently, he got the entry into the P11 by referring to the conversion. By misleading the reader.
What is his name?
P11, column number 10. Column number 9, Nagaraju bin Nandappa. ಸ್ವಾಧೀನರಾದ ಹೆಸರು ಮತ್ತು ವಿಳಾಸ ನರಸಿಂಹಯ್ಯ N Nagaraju bin Manjappa. MR number 57
Alienated.
Really?
ಅದು ಎಂ ನಾಗರಾಜು ಬಿನ್ ನಂಜಪ್ಪ alienated 20 guntas.
Additionally, why he kept quiet for these years without entering? Because the 11 guntas is reserved for public purpose that was not entered. If you boost the authorities, the conversion order has to be shown and it has to be entered. But here he has not shown that. And later on, colluding with the revenue authorities, he got his entry only subsequently.
In 2007.
By overriding the class and also for the purpose of this.
So, but as per this exhibit P11, 20 guntas is forthcoming here.
Forthcoming is for the conversion. It is not shown to the authorities. The conversion is subjected to 11 guntas of public purpose that has to be entered in that. But precisely,
All right. So, are you concerned with that 11 guntas?
Well, no, why I say this, 20 guntas belong to me and I am in possession of the property. But it is not so. You ask for the conversion order, you got only 9 guntas. That's what I want to say.
9 guntas.
Yes, 20 guntas are there. No, another gunta, public purpose of it. No more gunta. According to his own document, I am not let out, not put up any documents by me.
Yes. Then why you did not raise this issue when the injunction was granted for him?
No, I have cross-examined on this point also. That's what. By not the time is come to the cross-examination.
Yes.
Well, I kindly come to cross-examination, madam.
Page.
Page 56. Okay. Survey number Karnataka.
Yes.
Survey number 57 ಮಂಗಲ ಜಮೀನು 317 ಗುಂಟೆ ಇಟ್ಟಿದ್ದಾನೆ. ಸದರಿ ಜಮೀನು ಬಿಟ್ಟಾರೆಡ್ಡಿ ಕೃಷ್ಣಾರೆಡ್ಡಿ ಕಮಲಮ್ಮ ಜಯಮ್ಮ ಮತ್ತು ಸೇರಿತ್ತು. ಆ ಜಮೀನು ಕಾಯ್ದೆ ಮೂಲಕ ಮಂಗರೆಡ್ಡಿ ಕೃಷ್ಣಾರೆಡ್ಡಿ ಬಿಟ್ಟಾರೆಡ್ಡಿ ಪತ್ತಿ ಬಂದಿತ್ತು. ಕಮಲಮ್ಮನಿಗೆ ಈ ಜಮೀನು ಹೇಳುವಂತೆ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಕಮಲಮ್ಮನಿಗೆ ಮತ್ತು ಮುನಗಡ್ಡಿ ಕೃಷ್ಣಾರೆಡ್ಡಿ ಬಿಟ್ಟಾರೆಡ್ಡಿ ಜಮೀನಲ್ಲಿ ಎಷ್ಟು ವಿಸ್ತೀರ್ಣ ಇದೆ ಅಂತ ನನಗೆ ಹೇಳಲಾಗುವುದಿಲ್ಲ. ಕಮಲಮ್ಮ ಮುನಗಡ್ಡಿ ಕೃಷ್ಣಾರೆಡ್ಡಿ ಮತ್ತು ಬಿಟ್ಟಾರೆಡ್ಡಿ ಪರಸ್ಪರ ಸಂಬಂಧಿಕರು. ಅವ್ರ ನಡುವೆ ಯಾವುದೇ ಸಂಬಂಧ ಇಲ್ಲ ಎನ್ನುವುದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಅವ್ರ ನಡುವೆ ಸುಮಾರು 2010 ಆಸ್ತಿ ವಿಭಾಗವಾಗಿದೆ. ಈ ವಿಭಾಗ ಪತ್ರವನ್ನು ನಾನು ನೋಡಿಲ್ಲ. ಕಮಲಮ್ಮನವರಿಗೆ ಈ ಸರ್ವೆ ನಂಬರ್ 57 317 ಕೋಟಿ 43 ಗುಂಟೆ ಜಮೀನಿದ್ದರೆ ಜಮೀನು ಇತ್ತು. ಆದರೆ ಎಷ್ಟು ವಿಸ್ತೀರ್ಣ ಗೊತ್ತಿಲ್ಲ. ಉಳಿಕೆ 2 ಎಕರೆ 23 ಗುಂಟೆ ಜಮೀನು ಮುನಗಡ್ಡಿ ಕೃಷ್ಣಾರೆಡ್ಡಿ ಬಿಟ್ಟಾರೆಡ್ಡಿ ಮಕ್ಕಳ ಹೆಸರಿಗೆ ಖಾತೆ ಆಗಿದೆ ಅನ್ನೋದು ಸರಿ. ಜಯಮ್ಮ ಖಾತೆ ಮಕ್ಕಳು ಬಿಟ್ಟಾರೆಡ್ಡಿ ವಾಮಸ್ವಾಮಿ ಅನ್ನೋದು ಸರಿ. ಈ ರೀತಿ ಅವರ ಹೆಸರು ಖಾತೆಯಾಗುವವರಿಗೆ ಪ್ರತಿ ಜಮೀನು ಸರ್ವೆ ನಂಬರ್ 17 ಆಗಿತ್ತು ಅನ್ನೋದು ಸರಿ. ಸದರಿ 2 ಎಕರೆ 23 ಗುಂಟೆ ಜಮೀನು ಪೈಕಿ 1 ಗುಂಟೆ ಕಾಲಾವಧಿ ಜಮೀನು ಆಗಿದೆ ಅನ್ನೋದು ಸರಿ. ನಾನು ಕೂಡ ನಂತರ ಈ ಜಮೀನು ಸರ್ವೆ ನಂಬರ್ 57 ಒಂದು ವಿಭಾಗವಾಗಿದೆ. ಸದರಿ ಸರ್ವೆ ನಂಬರ್ 57 ಬಾರ್ ಒಂದೇ ಜಮೀನು 11 ಗುಂಟೆ ಕಾಲಾವಧಿ ಜಮೀನು ಇತ್ತು. ಉಳಿದ ಜಮೀನು 2 ಗುಂಟೆ ಮುನಗಡ್ಡಿ ಜಮೀನು ಸೇರಿದೆ. ನಾನು ಕೊಂಡುಕೊಂಡಾಗ ಸರ್ವೆ ನಂಬರ್ K1 ಸರಿ. ಕೃಷ್ಣಾರೆಡ್ಡಿ ಬಿಟ್ಟಾರೆಡ್ಡಿ ವಾರಸ್ದಾರ 57 ಬಾರ್ ಜಮೀನು ಯಾರಿಗೆ ಮಾರಾಟ ಮಾಡಿದ್ರು ನಮಗೆ ಗೊತ್ತಿದೆ ಅನ್ನೋದು ಸರಿಯಿಲ್ಲ. ಸರ್ವೆ ನಂಬರ್ 57 ಬಾರ್ 1 ಜಮೀನು ಹಿಂದೂ ರೋಡ್ ಸ್ವಾಧೀನ 84 ಬಿಡಿ ಹೊರಸಿದ್ದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಈ ಜಮೀನು ರಿಂಗ್ ರೋಡ್ ಆಗಿದೆ ಅನ್ನೋದು ಸರಿ. ಈ ರೋಡ್ ಆಗಿ 1 ಎಕರೆ 25 ಗುಂಟೆ ಜಮೀನು ಸರ್ವೆ ನಂಬರ್ 57 ಗೊತ್ತಿಲ್ಲ. ಆ ಪೈಕಿ ಕಮಲಮ್ಮನವರು 20 ಗುಂಟೆ ಮತ್ತು ಕೃಷ್ಣಾರೆಡ್ಡಿ 33 ಗುಂಟೆ ಜಮೀನು ಸೇರಿದೆ ಅನ್ನೋದು ಗೊತ್ತಿಲ್ಲ. ಕಲಾಪು ಜಮೀನು 11 ಗುಂಟೆ ಸಹ ರೋಡ್ಗಾಗಿ ಹೋಗಿದೆ ಅಂತ ಹೇಳ್ಬೋದು. ನಾವು ಜಮೀನು ರೈಲು ರಸ್ತೆ ಇತ್ತು. ಆ ರಸ್ತೆ ಬಗ್ಗೆ ನಾವು ನಕ್ಷೆ ಕೊಟ್ಟಿಲ್ಲ. 14 ನನಗೆ ಮುಂದಕ್ಕೆ ಟೆಕ್ನಾಲಜಿ ಕೊಟ್ಟರು ಈ ದಾಖಲೆಯಲ್ಲಿ ಅವರು ಸೈಗಳಿಲ್ಲ ಈ ಕೇಸ್ಗೋಸ್ಕರ ಸಭೆ ದಾಖಲೆ ನಾನು ತಯಾರು ಮಾಡಿದ್ರು ಸರಿಯಿಲ್ಲ ಬಿಡಿಎ ನಿಂದ್ರಸ್ಥೆಗೆ ವಿಭಿನ್ನ ಪ್ರೋತ್ಸಾಹಗಳನ್ನು ನಂತರ ಮುಂದಕ್ಕೆ ಟೆಕ್ನಾಲಜಿ ಅಲ್ಲಿ ಎಷ್ಟು ಆಸ್ತಿ ಉಳಿಸಿಕೊಂಡಿರುವ ದಾಖಲೆ ಇಲ್ಲ ನಾನು ಜಮೀನು ಕೊಂಡ ನಂತರ ನನ್ನ ಜಮೀನು ನಾನು ಸಭೆ ಮಾಡಿಸಿಕೊಂಡಿಲ್ಲ ಕನ್ವರ್ಷನ್ ಆದೇಶ ಮಾಡಿಸಿಕೊಳ್ಳುವ ನಾನು ಸಭೆ ನಕ್ಷೆಯನ್ನು ಸಂಬಂಧಪಟ್ಟಂತೆ ಕೊಟ್ಟಿದ್ದೇನೆ ಆ ದಾಖಲೆಯನ್ನು ನಾನು ನ್ಯಾಯಕ್ಕೆ ಹಾಜರುಪಡಿಸಲು ಆಗುವುದಿಲ್ಲ ಕನ್ವರ್ಷನ್ ಆದೇಶ ಮಾಡುವಾಗ ಯಾರಿಂದ ಎನ್ಒಸಿ ಪಡೆಯಲಾಗಿದೆ ಅನ್ನೋದು ಗೊತ್ತಿಲ್ಲ ನಮ್ಮ ಜಮೀನು ಪೂರ್ವಕ್ಕೆ ಕಮಲ ಲಕ್ಷ್ಮಿ ಜಮೀನಿದೆ ಕನ್ವರ್ಷನ್ ಆದೇಶ ಆಗುವವರಿಗೆ ಅದರಲ್ಲಿ ಕಮಲಮ್ಮ ಲಕ್ಷ್ಮಿ ಇನ್ನೂ ಜಮೀನು ಉಳಿದಿತ್ತು ನಮ್ಮ ಜಮೀನು ಪೂರ್ವಕ್ಕೆ ಅವರು ಸೇರಿದ ಯಾವುದೇ ಜಮೀನು ಇಲ್ಲ ಎನ್ನುವುದು ಸರಿಯಿಲ್ಲ ಕಮಲಮ್ಮ ಜಮೀನು ನಿಂದಷ್ಟೇ ಬರ್ತದೆ ಅಂದ್ರೆ ನಿಂದಷ್ಟೇ ವ್ಯವಹಾರ ಹೇಗಿರುತ್ತದೆ ನಾನು ಜಮೀನು ಕೊಳ್ಳುವ ವೇಳೆಗೆ ಪಶ್ಚಿಮಕ್ಕೆ ದೇವರು ಬಿಟ್ಟು ಹೋಗುವ ರಸ್ತೆ ಇತ್ತು ಎನ್ನುವುದು ಸರಿ ಸದರಿ ರಸ್ತೆ 15-20 ಅಡಿ ಅಗಲ ಇತ್ತು ಈ ಕಾಲಕ್ಕೆ ರಸ್ತೆ ಅಗಲವನ್ನು ಹಾಕಲಾಗಿತ್ತು ಅಂದ್ರೆ ಆಗಿದ್ದಿಲ್ಲ 2009 ಇನ್ನೂ ಅಗಲ ಮಾಡಲಾಯಿತು ಸರಿಯಿಲ್ಲ ಆರ್ಚನ್ನು 2006 ಮಾಡಲಾಗಿದೆ ಸದರಿ ರಸ್ತೆ ಆ ಕಾಲಕ್ಕೆ 20 ಅಡಿ ಅಗಲವಾಯಿತು ಗೊತ್ತಿಲ್ಲ ಈ ರೀತಿ ರಸ್ತೆ ಅಗಲ ಮಾಡುವಾಗ ನಾನು ಕೊಂಡುಕೊಂಡ ಜಮೀನು ಸಹ ರಸ್ತೆ ಅಗಲೀಕರಣಕ್ಕೆ ಪ್ರವೇಶವಾಗಿದೆ ಅನ್ನೋದು ಸರಿಯಿಲ್ಲ ಈ ರಸ್ತೆಯನ್ನು ಪಂಚಾಯತ್ ಮಾಡಿದ್ದಾರೆ ಎನ್ನುವುದು ಸರಿ Now minute, I stop at this. Now I request my lord to complete with D5.
D5?
D5, marked in the class examination of PW1. That is available for 178 on the paper book. The sketch is not available.
What is this D5?
D5 is the sketch prepared by the Sasudha. Aware.
D5. So this is prepared by?
Prepared by Sasudha. Saluk Samayan and Sasudha Bangalore people.
Yes.
These have been admitted by the basic to the class examination. Now my lord, kindly see this. Now note. These survey 57 year ನಕಾಶೆ ಅಂತೆ ಲಾಗ 20 ಅಡಿ ಬಂಡಿದಾರಿ ಇರುತ್ತದೆ ಈ ಬಂಡಿದಾರಿಗೆ ಈಗ ಮುಚ್ಚಿ ಹೋಗಿದ್ದು ಖಾಲಿ ಜಮೀನಿನ ಸ್ಥಿತಿಯಂತೆ ಈ ಗುಟ್ಟಿನಿಂದ ತೋರಿಸಿರುವಂತೆ 32 ಅಡಿ ಅಗಲ ರಸ್ತೆಯಾಗಿ ಆಗುವುದು ಅದರಂತೆ ಅಡ್ಡಿದಾರಿ ದಾರಿ ಬಗ್ಗೆ ನಡೆಸಿದ್ದಾರೆ. The property which came to be taken by the franchise from formation of road from 20 feet to 32 feet. If that is taken into consideration, towards western side, the first property belongs to the mayor, second property belongs to the franchise, and other properties belong to owners. Where 12 feet has been used for the purpose of road.
Where is this 57/1A in this sketch on top and how? Which is this 20 guntas here?
20 guntas. Okay, 57/A1 ನಲ್ಲಿ ರಸ್ತೆಗಾಗಿ ನಕ್ಷೆ ಮಾಡಿದ್ರು. ರಸ್ತೆ what has been from Devapur to main road.
Read that note below. What again? 57/1A ಅಲ್ಲಿ
1A ನಲ್ಲಿ ನಕಾಶೆ ಇರುತ್ತೆ 20 ಅಡಿ ಗಡಿದಾರಿ
20 ಅಡಿ
20 feet
cart road.
ಇರುತ್ತದೆ. ಈ ಬಂಡಿದಾರಿ ಇಂದ ಮುಚ್ಚಿ ಹೋಗಿತ್ತು ಖಾಲಿ ಜಮೀನಿನ ಸ್ಥಿತಿಯಲ್ಲಿ ಆಸ್ಪತ್ರೆ ಸ್ಟೇಟಸ್ ಈ ಗುರುತಿನಿಂದ ತೋರಿಸಿರುವಂತೆ 30 ಅಡಿ ಅಗಲದಲ್ಲಿ ರಸ್ತೆಯಾಗಿ ಹಾದು ಹೋಗಿ ಅದರಂತೆ 14 ಕೋಟಿ ಸ್ಥಳ ಪರಿಶೀಲನೆ ಮಾಡಿ ದಾರಿ ಬಗ್ಗೆ ನಮಗೆ ಇದೆ. So it is the specific case where the extent whatever the plaintiff has got is also used for the purpose of extension of the village road. And similarly 20 feet is well property also the spot.
ಬಂಡಿ ದಾರಿ ಅದು ಕ್ಲೋಸ್ ಆಗಿದೆ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
ಬಂಡಿ ದಾರಿ ಕ್ಲೋಸ್ ಆಗಿ ಪ್ರೆಸೆಂಟ್ ರಸ್ತೆ ಮಾಡಿದ್ದಾರೆ.
ಏನ್ ಮಾಡಿದ್ದಾರೆ? ರಸ್ತೆ.
Main road from Dev Vishnu to Ring Road.
That is shown in that red and blue.
Yes.
Red line in between blue. That is what extent?
That is extent 32 feet, more than that.
All right. All right. How are you relating that to this case?
Yes, the specific convention development right. The extent of land which belongs to plaintiff is also acquired for the purpose of formation of Dev Vishnu. And similarly, the property, my property also 20 feet has been used for the purpose of road.
How is that coming between this 20 guntas of land? You have to say.
That towards western side comes. Therefore, it is marked to him only.
Oh, this whole thing is prepared by the Tahsildar. This is pertaining to 57/1A. What is the total extent of 57/1A? Right. So now you have to restrict your claim whether that Bandi Raste and that new Raste which is made, whether it is coming within this 20 guntas of land which he is claiming belongs to him. And
Yes, that's what we say in Belak.
where is that finding?
Yes, Belak behind this come to 160. At the cost of petition. That is get prepared.
Yes.
Belak behind this thing. Towards 143 feet. Alle the strong road is the road which goes to Dev Vishnu. That's happening. So first property ring road ಆದ್ಮೇಲೆ ಬರುತ್ತೆ ರೈಟ್ road. So ಅಲ್ಲಿಂದ 12 ಅಡಿಗೆ 243 ಅಡಿ ರೋಡ್ ಫಾರ್ಮ್ ಮಾಡಿದ್ರೆ 20 ಗುಂಟೆ ನೀರು.
20 ಗುಂಟೆ?
20 ಗುಂಟೆ ಇದೆ. 12 feet by 143 feet is used for the purpose of road, village road. Then it comes to only 7.5 guntas available land.
7.5 guntas.
17.5.
17.5. So if it is 12
by 143 feet.
12 feet by 143. So that 12 feet has to be deducted out of the 20 guntas is what you are trying to say. So in this exhibit D5, the blue line, the red line and the blue color, which is marked, is that 12 feet by 143 feet.
And also 12 feet by 20 feet in my property. It passes through my property also.
Again?
ಈಗ 143 ಆದ್ಮೇಲೆ next property ನಂದೆ. ಅದು ಹಂಗೆ ಹೋಗುತ್ತೆ. ಒಂದು ಕಾರ್ನರ್ ಅಲ್ಲಿ.
No. If it is 12 feet by 143, either it has to fall in the property belonging to him.
No. In the property of plaintiff only 143 feet. That's what I refer to it. The 100.
Ah.
143ಕ್ಕೆ 12 ಅಡಿ ಬರ್ತದೆ. Page 116. ಅದಾದ್ಮೇಲೆ ಆ ಕಾರ್ನರ್ ಅಲ್ಲಿ ಎಡ್ಜ್ ಹೋಗುತ್ತೆ. ಆ ಎಡ್ಜ್ಗೆ ನನ್ನ ಪ್ರಾಪರ್ಟಿ. ನೆಕ್ಸ್ಟ್ ಪ್ರಾಪರ್ಟಿ ಆಫ್ಟರ್ 143 ನಂದೇ ಪ್ರಾಪರ್ಟಿ.
Towards left or right?
Towards left. That's same village road. ಅದಕ್ಕೆ ವರ್ಣನೆ ಮಾಡಿ.
No. 143 ಪಕ್ಕದಲ್ಲಿ there is one on the left, one on the right. Left belongs to him.
143 feet belongs to the building. 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 ಅದಾದ್ಮೇಲೆ 57 1 year ಸೇರಿ ಆ ಕಾರ್ನರ್ ಶಾರ್ಟ್ ಇರ್ತದೆ. ಅದು ನನ್ನ ಪಾತ್ರ. ಅದ್ರಲ್ಲಿ 20 ಅಡಿ ಹೋಗಿ.
ಅದರಲ್ಲಿ 20 ಅಡಿ ಹೋಗಿದೆ. 20 feet. 20 by
20 feet by only the corner, only a small portion. 20 ಅಡಿಗೆ ಅವರು 12 ಅಡಿ.
Yes.
Start at 19 or after 16.
Page 16, huh?
Yes, 16, chapter 19. Last paragraph. ಈ ರೀತಿ ರಸ್ತೆ ಅಗಲ ಮಾಡುವಾಗ ಮೇಲಾಗ
ಇಲ್ಲಿ
4 ಲೈನ್ ಕೆಳಗಿಂದ
ಯಾವಾಗ 20ನೇ ಪ್ಯಾರಾನೋ 19?
19ನೇ ಪ್ಯಾರಾ.
ಈ ರೀತಿ
ರಸ್ತೆ ಅಗಲ ಮಾಡುವಾಗ ನಾನು ಕೊಂಡುಕೊಂಡ ಜಮೀನು ಸಹ ರಸ್ತೆ ಅಗಲೀಕರಣಕ್ಕೆ ಉಪಯೋಗ ಆಗಿಸಿದೆ ಎನ್ನುವುದರಿಂದ ಆ ರಸ್ತೆಯನ್ನು ಪಂಚಾಯತ್ನವರು ಮಾಡಿದ್ದಾರೆ ಎನ್ನುವುದು ಸರಿ.
read that again. ಈ ರೀತಿ
ರಸ್ತೆ ಅಗಲ ಮಾಡುವಾಗ ನಾನು ಕೊಂಡುಕೊಂಡ ಜಮೀನನ್ನು ಸಹ ರಸ್ತೆ ಅಗಲೀಕರಣಕ್ಕಾಗಿ ಉಪಯೋಗಿಸಿದೆ ಎನ್ನುವುದು ಸರಿಯಲ್ಲ. ಆ ರಸ್ತೆಯನ್ನು ಪಂಚಾಯತ್ನವರು ಮಾಡಿದ್ದಾರೆ ಎನ್ನುವುದು ಸರಿ.
by the panchayat. What is this document? What is this? Cross examination. Okay. Yes.
ನನ್ನ ಜಮೀನ ದಕ್ಷಿಣಕ್ಕೆ ನನಗೆ ಮಾರಾಟ ಮಾಡಿದ ವ್ಯಕ್ತಿಗಳು 1 ಎಕರೆ 20 ಗುಂಟೆ ಅಥವಾ 1 ಎಕರೆ 30 ಗುಂಟೆ ಉಳಿಸಿಕೊಂಡಿದ್ದರು. ಅವ್ರು ಸುಮಾರು 15 ಜನಕ್ಕೆ ಜಮೀನು ಮಾರಾಟ ಮಾಡಿದ್ರು ನಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ. ಈ ರೀತಿ ಜಮೀನನ್ನು ಸೈಕಲಾಗಿ ಮಾಡಿ ಮಾರಾಟ ಮಾಡಿದ್ದಾರೆ ಅನ್ನೋದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಆ ರೀತಿ ಮುಂದೆ ಪ್ರಸ್ತಾವ 2 ಪ್ರಸ್ತಾವದಿಂದ 66,7 37,2000 ನನಗೆ ಗೊತ್ತಿಲ್ಲ. 1 ಗುಂಟೆ ಜಮೀನು ಒಂದೇ ಪ್ರತಿವಾದಿ ಕೃಷ್ಣಾರ್ಜುನ ಮಾಡಿಲ್ಲ. ಇನ್ನೊಂದು ಗುಂಟೆ ಜಮೀನು ಬಿಡಾಗಿ ಮಾಡ್ತಾ ಕೊಂಡ್ಕೊತಾ ಇರೋ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಒಂದನೇ ಪ್ರತಿವಾದಿ ಕೊಂಡ್ಕೊಂಡ ಜಮೀನುಗಳನ್ನು ನಾನು ಕೊಂಡ ಜಮೀನಿಗೆ ದಕ್ಷಿಣಕ್ಕೆ ಇದೆ ಅನ್ನೋದು ಸರಿ.
ಒಂದನೇ ಪ್ರತಿವಾದಿಯ
ಕೊಂಡಿರುವ ಆ ಜಮೀನುಗಳೆಲ್ಲವೂ ನಾನು ಕೊಂಡ ಜಮೀನಿಗೆ ದಕ್ಷಿಣಕ್ಕೆ ಇದೆ ಎನ್ನುವುದು ಸರಿ. southern side
your properties.
ಆಮೇಲೆ 2003ರಲ್ಲಿ ನಾನು ನಮ್ಮ ಜಮೀನಿನಲ್ಲಿ ಹೋಟೆಲ್ ಕಟ್ಟಿಸಲು ಪ್ರಾರಂಭಿಸಿದೆ. ನಾನು ನನ್ನ ಕಟ್ಟಡಕ್ಕೆ ಸುತ್ತಲೂ ಕಾಂಪೌಂಡ್ ಹಾಕಿದ್ದಾನೆ ಎನ್ನುವುದು ಸರಿಯಲ್ಲ. ಈಗ ತೋರಿಸಿದ ಫೋಟೋ ನನ್ನ ಸೊತ್ತಿಗೆ ಹಾಕಿರುವ ಕಾಂಪೌಂಡ್ ಎಂದರೆ ಒಂದು ಭಾಗಕ್ಕೆ ಹಾಕಿರುವ ಕಾಂಪೌಂಡ್. ವಿಶೇಷ ಕಾಂಪೌಂಡ್ ಇಲ್ಲ, ನಾನು ಒಂದು ಭಾಗಕ್ಕೆ ಹಾಕಿದ್ದೇನೆ. ಸಾಕ್ಷಿ ಘೋಷಿಸಿದ ಸದರಿ ಫೋಟೋವನ್ನು ಒಂದು D1 ಎಂದು ಕಾಂಪೌಂಡಿನ ಭಾಗವನ್ನು D1 ಎಂದು ಗುರುತಿಸ್ತಾ ಇತ್ತು.
D1 compound D1 ಏನ
D1 D2 D3 all the three photos.
D1
ಕಾಂಪೌಂಡಿನ ಭಾಗವನ್ನು D1A, ಕಾಂಪೌಂಡ್ ಪೋರ್ಷನ್ ಅನ್ನು ಮಾತ್ರ D1A. ಮೇಲಾಟ. ಎರಡು ಸಾವಿರದ 3-4ರಲ್ಲಿ ಈ ಕಾಂಪೌಂಡ್ ಅನ್ನು ಹಾಕಲಾಗಿದೆ.
This is already entirely constructed area.
Yes, that's what totally building was constructed. Compound was laid. And when I started putting up the construction and at that juncture we have started. And we started to run the hotel also by giving to the lease.
So D1 is the picture. D1A is a compound wall.
Compound wall. And 2003-4ರಲ್ಲಿ ಕಾಂಪೌಂಡ್ ಅನ್ನು ಹಾಕಲಾಗಿದೆ ಈ ಎಫೆಕ್ಟ್ಸ್. ಈಗ ತೋರಿಸಿದ D1 ರಲ್ಲಿ ಮೇಲಾಟ ಕಾಣುತ್ತಿರುವ ಕೆಂಪು ಬಣ್ಣದ ವಸ್ತು ಒಂದನೇ ಪ್ರತಿಪಾದಿತ ಸೂತ್ರದಲ್ಲಿ ಬೋರ್ವೆಲ್ ಪಂಪ್ಗಾಗಿ ಹಾಕಲಾಗಿರುವ ಮೀಟರ್ನ ಬೋರ್ಡ್. I have done the borewell. Meter board are installed. And the red mark was marked. And the center is compound.
That is in D1.
D1. D1B is the meter board.
Yes.
ಈಗ ತೋರಿಸಿದ ಫೋಟೋವನ್ನು D2 ಎಂದು ಸಾಕ್ಷಿ ತೋರಿಸಿದ್ರು.
ಆ D1 ಅಲ್ಲಿ ಆ ರೆಡ್ ಕಲರ್ ಮೀಟರ್ ಬಾಕ್ಸ್ ಇದೆಯಲ್ಲ, that comes in whose portion?
My portion.
The compound wall is right side is his portion.
This portion in the pillar we have laid. Now meter ಕಟ್ಟ ಕಟ್ಟೋದಕ್ಕೆ ಬೋರ್ವೆಲ್ ನೀರು ತಗೊಳ್ಳೋದು.
So you are having the photo with you? You are having photograph of D1?
That's what I produced.
Correct. You can show from there that wall and that red portion. Or you can come here. This is the photo you're talking about.
Yes, ma'am.
This is D1. This is the red portion. What is this?
This is meter board. My pillar.
Your pillar.
ಹೌದು, ನಾನು ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡ್ತಾ pillar.
What about this wall?
This wall is the compound wall.
Belonging to?
Belonging to painting.
Yes. So this is your portion. This is
That is portion.
So this meter board is put by you in your portion.
In my portion.
This wall is constructed by him.
By him.
But he says there was no wall.
No, he admits in the examination further. He says no. Then he says admits yes.
Is the property belonging to him?
It belong to him. That's all I got. D2 my kindly visit. That's last. Construction of pillars ಎಲ್ಲ ಇದೆ.
This is your portion.
My portion.
This is his building.
His building. Yes, madam. This is building.
So his building has come up fully.
Full of in 2003 itself it has come up.
Yes. What about D3? What is this D3?
The D3 is the showing that my pillars are there.
They're putting up construction.
We are putting up.
Yes.
After continuing reading, page 21. ನನ್ನ ಸೊತ್ತಿಗೆ ಹಾಕಿರುವ ಕಾಂಪೌಂಡ್ ಎಂದರೆ ಒಂದನೇ ಭಾಗಕ್ಕೆ ಹಾಕಿರುವ ಕಾಂಪೌಂಡ್ ಮೇಲೆ
Para 20 na?
21. ನನ್ನ ಸೊತ್ತಿಗೆ ಹಾಕಿರುವ ಕಾಂಪೌಂಡ್ ಎಂದರೆ ಒಂದು ಭಾಗಕ್ಕೆ ಹಾಕಿರುವ ಕಾಂಪೌಂಡ್. ಸಾಕ್ಷಿ ಗುರುತಿಸಿದ ಸದರಿ ಫೋಟೋವನ್ನು D1 ಎಂದು ಕಾಂಪೌಂಡಿನ ಭಾಗವನ್ನು D1 ಎಂದು ಗುರುತಿಸಲಾಯಿತು. 2003-4ರಲ್ಲಿ ಈ ಕಾಂಪೌಂಡ್ ಅನ್ನು ಹಾಕಲಾಗಿದೆ.
He has put it.
ಈಗ ತೋರಿಸಿದ D1 ಬಗ್ಗೆ ಕಾಣುತ್ತಿರುವ ಕೆಂಪು ಬಣ್ಣದ ವಸ್ತು ಒಂದನೇ ಪ್ರತಿವಾದಿ ತನ್ನ ಸೊತ್ತಿನಲ್ಲಿ ಬೋರ್ವೆಲ್ ಪಂಪಿಗಾಗಿ ಹಾಕಿರುವ ನೀರಿನ ಬೋರ್ಡು ಇನ್ನೊಂದು ಸರಿ ಸಾಕ್ಷಿ ಗುರುಸಿದ ಸದರಿ ಮೀಟರ್ ಬೋರ್ಡ್ ಅನ್ನು 1B ಎಂದು ಗುರುತಿಸಲಾಯಿತು. ಈಗ ತೋರಿಸಿದ ಫೋಟೋವನ್ನು D2 ಎಂದು ಸಾಕ್ಷಿ ಗುರುಸಿದ ಮೀಟರ್ ಬೋರ್ಡ್ ಅನ್ನು D2 ಎಂದು ಗುರುತಿಸಲಾಯಿತು. ಈಗ ತೋರಿಸಿದ D2 ಪಿಲ್ಲರ್ ಅನ್ನು ಹಾಕಿ ಕಟ್ಟಲಾಗಿರುವ ಕಟ್ಟಡ ಒಂದನೇ ಪ್ರತಿವಾದಿ ಎನ್ನುವುದು ಸರಿ. ಸಾಕ್ಷಿ ಗುರುಸಿದ ಸದರಿ ಕಟ್ಟಡ ಭಾಗವನ್ನು D2 ಎಂದು ಗುರುತಿಸಲಾಯಿತು. ನಾನು ನನ್ನ ಸೊತ್ತಿಗೆ ಹಾಕಿಕೊಂಡಿರುವ ಕಾರಣ ಒಂದೇ ಪ್ರತಿವಾದಿಯು ತನ್ನ ಸೊತ್ತಿನಲ್ಲಿ ಒತ್ತುವರಿ ಮಾಡಿಕೊಂಡಿಲ್ಲ ಎನ್ನುವುದು ಸರಿಯಲ್ಲ. ಒಂದನೇ ಪ್ರತಿವಾದಿಯ ಕಟ್ಟಡವು ಆತ ಕೊಂಡ ಜಮೀನಿನಲ್ಲಿದೆ ಎನ್ನುವುದು ಸರಿಯಲ್ಲ. ಒಂದನೇ ಪ್ರತಿವಾದಿಯ ಕಟ್ಟಡ ಪೂರ್ವ ಪಶ್ಚಿಮ 64 ಫೀಟ್ 65, ಉತ್ತರ ದಕ್ಷಿಣವಾಗಿ 40 ವಿಸ್ತೀರ್ಣ ಎನ್ನುವುದು ಸರಿ. Admits my measurement. What is stated in column 38 my lords. ಒಂದನೇ ಪ್ರತಿವಾದಿ ಕೊಂಡ ಜಮೀನು 20ರ ಜಮೀನು 7ರ ಮೇಲೆ ರಸ್ತೆ ಆಗಲಿ ಚೆನ್ನಾಗಿ ಹೋಗುವುದನ್ನು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. Therefore, I confronted Deputy Fact to his task. Take me up. Column 24, column 24, column 23. ಒಂದನೇ ಪ್ರತಿವಾದಿ ಸತ್ತನ್ನು ಹೊರತುಕೊಳ್ಳಲು ಹಾಗೂ ಆತನ ತೊಂದರೆಯನ್ನು ಉದ್ದೇಶಿಸಿದ ಕೇಸ್ ಹಾಕಲಾಗಿದೆ ಎನ್ನುವುದು ತಿಳಿಯಿಲ್ಲ. Column 24. ಸರ್ವೆ ನಂಬರ್ 57/1 ಒಟ್ಟಿಗೆ 11 ಗುಂಟೆ ಕರಾವು ನಿಶಾನೆ P1 ಪ್ರಕಾರ ನನಕೊಟ್ಟ ಖರೀದಿದಾರರಿಗೆ 2 ಗುಂಟೆ ಸೇರಿತ್ತು. ಉಳಿದ ಜಮೀನು ಕಮಲಮ್ಮನವರು ಸೇರಿತ್ತು. Admits that the substance is erased from the property. P1ರಲ್ಲಿ P1 33 ಗುಂಟೆಗೆ ಬೀದಿಗೆ ರಿಂಗ್ ರೋಡ್ ಸ್ವಾಧೀನ ಎಂದು ಬರೆದಿದೆ. ನಾನು 20 ಗುಂಟೆ ಜಮೀನು ಹೊಂದಿದ್ದೇನೆ. ನನಗೆ ಹೈಕೋರ್ಟ್ 33 ಗುಂಟೆಗೆ ಉಳಿದಿದೆ ಅಂದರೆ ಸಾಕ್ಷಿ ವಿಸ್ತೀರ್ಣ ಗೊತ್ತಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. ನಾನು ಕೂಡ ಜಮೀನು ತಕ್ಷಣ ಜಮೀನು ಉಳಿಯಿತು. P1ರಲ್ಲಿ ಪೂರ್ವಕ್ಕೆ ಕಮಲಮ್ಮ ಹಾಗೂ ಲಕ್ಷ್ಮಿಯವರು 57/1 ಬರೆದಿದ್ದೆ. ನಾನು ಕೊಂಡುಕೊಂಡ ಮೇಲೆ ಜಮೀನು ಹದ್ದುಬಸ್ತು ಮಾಡಿಲ್ಲ. ಬೌಂಡರಿ ಸರ್ಟಿಫಿಕೇಟ್ ಟ್ರೈಬಲ್ ಪ್ರಾಫಿಟ್ ನಾನು ಸರ್ವೆ ಕೊಟ್ಟಿಲ್ಲ. ದಾವಾ ಹಾಕಲು ಒಂದು ಸರ್ವೆ ಮಾಡೋ ಪ್ರಯತ್ನ ಪಟ್ಟೆ ಸೇರಿಸಿಲ್ಲ. ಖಾಸಗಿ ಸರ್ವೆ ಮಾಡಿಸಿದೆ. ಖಾಸಗಿ ಜಮೀನು ಸರ್ವೆ ಮಾಡಿ ನನ್ನ ಜಮೀನು ಹದ್ದುಬಸ್ತು ತೋರಿಸಿದ್ರು. ಭಾರತ ಸರ್ವೆ ಮ್ಯಾಪಿಂಗ್ ಕಂಪನಿ ಮಾಡಿಸಿದ್ದ ಅನುಸಂಖ್ಯೆಯಲ್ಲಿದೆ. ಸರ್ವೆ ಮಾಡಿಸಿಕೊಂಡೆ ದಾಖಲೆಯನ್ನು ಹಾಜರುಪಡಿಸಿಲ್ಲ. ನಾನು ಕೊಂಡು 20 ಗುಂಟೆ ಆ ಸರ್ವೆ ನಮಗೆ ಎಲ್ಲಿ ಬರ್ತಿದೆ ನನಗೆ ಸಂಶಯ ಇದೆ ಎನ್ನುವುದಿಲ್ಲ. ನನ್ನ ದಾವಾ ಸೂಚನೆ ತೆಗೆದುಕೊಂಡಲ್ಲಿ ಪ್ರತಿವಾದಿಯ ಜಮೀನು ತೋರಿಸಿಲ್ಲ. ಒಂದನೇ ಪ್ರತಿವಾದಿಯ ಜಮೀನು ನನ್ನ ಜಮೀನಿನ ದಕ್ಷಿಣ ಒಂದು ಭಾಗಕ್ಕೆ ಬರುತ್ತದೆ. ನನ್ನ ಸೊತ್ತಿನ ದಕ್ಷಿಣದ ಒಂದು ಭಾಗಕ್ಕೆ ಕಾಂಪೌಂಡ್ ಹಾಕಿದ್ದೇನೆ. ಸದರ್ನ್ ಸೈಡ್ ರಿಲೇಟ್ಸ್ ಕಾಂಪೌಂಡ್. ಈ ದಾವಾ ಹಾಕುವ ಸಮಯದಲ್ಲಿ ಆ ಕಾಂಪೌಂಡ್ ಇತ್ತು. ಅದನ್ನ ಡೇಟ್ suit itself compound was existed. Compound ಪಕ್ಕದಲ್ಲಿ ಒಂದೇ ಪ್ರಕಾರ ಸೊತ್ತು ಬರ್ತದೆ ಎಂದು ಸರಿಯಿಲ್ಲ. ದಕ್ಷಿಣಕ್ಕಿರುವ ನಮ್ಮ ಕಾಂಪೌಂಡ್ ಪಕ್ಕ 2 ಪ್ರತಿವಾದಿ ಕಟ್ಟ ಇದೆ. ಕಾಂಪೌಂಡ್ ಪಕ್ಕ ಒಂದೇ ಪ್ರತಿವಾದಿ ಕಟ್ಟ ಇರುವ ಸರಿಯಿಲ್ಲ. ನನ್ನ ಸಮಸ್ತಿನ ಪಶ್ಚಿಮಕ್ಕೆ ಡ್ರೈನೇಜ್ ಇದೆ. ಈ ಕೇಸಲ್ಲಿ ಹಾಜರುಪಡಿಸಿರುವ ಫೋಟೋ ನನ್ನ ಸ್ವತ್ತಿಗೆ ಸಂಬಂಧಿಸಿದ್ದು. ಇದನ್ನು D3 ಎಂದು ಗುರುತಿಸಲಾಯಿತು. D3 ನಲ್ಲಿ ಕಾಣಿಸುತ್ತಿರುವ ಕಟ್ಟಡ 2007ಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಿದ್ದು. ಸದರಿ ಫೋಟೋವನ್ನು 29/2005 ಸಾಕ್ಷಿ ನಮಗೆ ಗೊತ್ತಿಲ್ಲ ಎನ್ನುತ್ತಾರೆ. 2007 ಮಳೆಯಿಂದ ನನ್ನ ಕಾಂಪೌಂಡ್ ಬಿದ್ದಿತ್ತು. ಈಗ ತೋರಿಸಿದ ದಾಖಲೆ ಪಿನಾರಿಟಿ ಎಂಟ್ರಿ ದೇವಮ್ಮನವರು ಮತ್ತು ಪಿನಾರಿಟಿ ತಮ್ಮ ಕೃಷ್ಣಾರೆಡ್ಡಿ ಮತ್ತು ಒಗ್ಗಟ್ಟಿಯವರಿಗೆ ಅದನ್ನು ನಿಜಾನೆ 4 ಎಂದು ಗುರುತಿಸಲಾಯಿತು. ನಿಶಾನೆ D1ರಲ್ಲಿ ಪ್ರೈವೇಟ್ ಆತ 33 ಗಂಟೆ ಜಮೀನು ಬಂದಿದೆ. ಅವರದೇ ಸೇಮ್ 33 ಗುಂಟ 33 ಗುಂಟೆಯನ್ನು ಈ ಅಡ್ಮಿಟ್ಸ್ ಬಂದಿದೆ. 33 ಗುಂಟೆ 3 ಭಾಗವಾಗಿ ವಿಂಗಡಿಸಿದ್ದಾರೆ. ನಿಶಾನೆ D4 ಪ್ರಕಾರ A ಶೆಡ್ಯೂಲ್ ದೇವಮ್ಮ ಮತ್ತು ಅವರ ಮಗಳಿಗೆ ಸೇರಿದೆ. B ಶೆಡ್ಯೂಲ್ ಮತ್ತು ಕೃಷ್ಣಾರೆಡ್ಡಿಗೆ ಸೇರಿದೆ. C ಶೆಡ್ಯೂಲ್ ಮತ್ತು ಮುನರೆಡ್ಡಿಗೆ ಸೇರಿದೆ. A ಶೆಡ್ಯೂಲ್ ನಲ್ಲಿ 2 ಐಟಮ್ ಇದ್ದು, ಒಂದು 6 ಗುಂಟೆ ಇನ್ನೊಂದು 1 ಗುಂಟೆ. B ಶೆಡ್ಯೂಲ್ ನಲ್ಲಿ 11 ಗುಂಟೆ ಮತ್ತು 1 ಗುಂಟೆ. C ಶೆಡ್ಯೂಲ್ 5 ಗುಂಟೆ ಮತ್ತು 7 ಗುಂಟೆ. ಒಂದನೇ ಪ್ರತಿವಾದಿ ಜಮೀನಿನಿಂದ 1 ಗುಂಟೆ ಕೃಷ್ಣಾರೆಡ್ಡಿಯಿಂದ 1 ಗುಂಟೆ ಜಮೀನನ್ನು ಕೊಂಡುಕೊಂಡರು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಮುನ್ನಡೆಯಿಂದ ಪೂರ್ವ ಪಶ್ಚಿಮ 66 ಕೊಂಡುಕೊಂಡು ಗೊತ್ತಿಲ್ಲ. ಪ್ರತಿವಾದಿ ಆ ರೀತಿ ತಮ್ಮ ಲಿಖಿತ ಹೇಳಿಕೆಯಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ. ಸ್ಟೇಟ್ಮೆಂಟ್ ನನ್ನ ಸೊತ್ತಿನ ಪಶ್ಚಿಮಕ್ಕೆ ದೇವರ ಕೃಷ್ಣ ರಸ್ತೆ ಬರುತ್ತದೆ. So he said that the road has not been disputed. Now he admits. ಒಂದನೇ ಪ್ರತಿವಾದಿ ಸೊತ್ತಿನ ಪಶ್ಚಿಮಕ್ಕೂ ದೇವರ ಬೆಚ್ಚನಲ್ಲಿ ರಸ್ತೆ ಬರುತ್ತದೆ. He admits. Which I brought you my lords. The sketch which says the extent of road formed in 12 feet by 147 and 12 feet by 20 feet by property. ಸದರಿ ರಸ್ತೆ ಆಗಿಲ್ಲ 33 ಅಡಿ 32 ಅಡಿ ಇದ್ದ ಸಾಕ್ಷಿ ನಾನು ನೋಡಿಲ್ಲ ಎಂದು ಹೇಳ್ತಾರೆ. ನಾನು ಕೊಂಡಾಗ ರಸ್ತೆ ಆಗ 25 ಇದ್ದ ಸಾಕ್ಷಿ 30 ಅಡಿ ಇತ್ತು ಎಂದು ಹೇಳ್ತಾರೆ. ಈಗ ತೋರಿಸಿದ ತಹಸೀಲ್ದಾರ್ ಸ್ಕೆಚಿನ ಪ್ರಕಾರ ದಾಖಲೆ ಇದೆ. ಸದರಿ ಸ್ಕೆಚ್ ಅನ್ನು ಡಿ5 ಎಂದು ಗುರುತಿಸ್ತಾ ಇತ್ತು. ತಮಗೆ 57 ಈಗ ಮುಂದೆ ಏನೋ ಆಗಿರಬಹುದು. ಅದೇ ಕೊಟ್ಟುಕೊಟ್ಟಿರುವ ಜಮೀನು ಅವರ ಹೆಸರು ಖಾತೆಯಾಗಿದೆ. ವಾಣಿಜ್ಯ ಹೆಸರು ಬಂದಿಲ್ಲ ಅಂದರೆ ಸಾಕ್ಷಿ ಕನ್ವರ್ಷನ್ ಆದ್ರಿಂದ ಹೆಸರು ಬಿಟ್ಟಿದೆ ಎಂದಿದ್ದಾರೆ. But subsequently 2007 that included because his name was not included because of the public purpose of revenue. Survey number 57 ನಲ್ಲಿ 32 ಜನ ಸಾಧನೆ ಜನಸಾಕ್ಷಿ ಗೊತ್ತಿಲ್ಲ. ನನ್ನ ಸಂದೇಶ ನಂಜಪ್ಪ ಸರ್ವೆ ಇಲಾಖೆಯಿಂದ 19 ಅದರ ದೂರವಾಣಿ ತಿಳಿಸಿದ್ದಾರೆ. ಕೋರ್ಟಿನಲ್ಲಿ ದಾವ ಇರೋದ್ರಿಂದ ಸರ್ವೆ ಮಾಡಬಾರದು ಅಂತ ಹೇಳಿದ್ರೆ ನನ್ನ ತಕರಾರಿನಿಂದ ಸರ್ವೆ ಆಗಿಲ್ಲ ಸರಿ ನಾವೇ ನಾನು 11 ಗಂಟೆ ಕರಾಬನ್ನು ಸೇರಿಸಿ 20 ಗಂಟೆ ಕೊಂಡುಕೊಂಡಿದ್ದೇನೆ ಎಂಬುದು ಸರಿಯಲ್ಲ. ಸ್ಪೆಸಿಫಿಕಲಿ ಆಸ್ಕ್ ಕನ್ವರ್ಷನ್ ಕ್ಲಾಸ್ 6 ಎಕ್ಸಿಬಿಟ್ P3 ವ್ಯವಸಾಯಗಳ ಉದ್ದೇಶಕ್ಕಾಗಿ ಆಗಿರುವ ಆಸೆ ದಟ್ ಇಸ್ ಕನ್ವರ್ಷನ್ ಆರ್ಡರ್. ಒಂದನೇ ಪ್ರತಿವಾದಿ ನನ್ನ ಸೇರಿದ ಯಾವುದೇ ಸ್ವತ್ತನ್ನು ಅತಿಕ್ರಮಣ ಮಾಡಿಲ್ಲ ಎನ್ನುವುದು ಸರಿಯಲ್ಲ. ದಾವಾದ ಬಿ ಶೆಡ್ಯೂಲ್ ಸ್ವತ್ತಿನ ನನಗೆ ಯಾವುದೇ ಹಕ್ಕಿಲ್ಲ ಎನ್ನುವುದು ಸರಿಯಲ್ಲ. ಒಂದನೇ ಪ್ರತಿವಾದಿ ಸ್ವತ್ತನ್ನು ಹೊರಟುಕೊಳ್ಳುವ ಉದ್ದೇಶದಿಂದ ಈ ಸುಳ್ಳು ದಾವೆಯನ್ನು ಹಾಕಿದ್ದೇನೆ ಎನ್ನುವುದು ಸರಿಯಲ್ಲ. ದಾವಾ ಸ್ವತ್ತಿನ ಪೂರ್ಣಕ್ಕೆ ಮುನರೆಡ್ಡಿಯವರ 57/1ರಲ್ಲಿ ಜಮೀನು ಹುಟ್ಟಿಕೊಂಡಿದ್ದಾನೆ ಸರಿಯಲ್ಲ. ದಾವಾ ಸ್ವತ್ತಿನ ಪಶ್ಚಿಮದಲ್ಲಿ ಬಿಜೆಪಿಯವರು ಹೊಸದಾಗಿ ರಸ್ತೆ ನಿರ್ಮಿಸುತ್ತಾರೆ ಎನ್ನುವುದು ಸರಿಯಲ್ಲ. ಇದರ ಬಗ್ಗೆ ನಾನು ಸುಳ್ಳು ಸಾಕ್ಷಿ ಇಟ್ಟಿದ್ದೇನೆ ಸರಿಯಲ್ಲ. ದಾವಾ ಸ್ವತ್ತಿನ ನಾನು ಕಟ್ಟಿರುವ ಕಟ್ಟಡ ಮತ್ತೆ ನೋಡಿದೆ ಹೇಳಲಾರೆ. ಅದೇ ಸ್ವತ್ತಿನ ಸುತ್ತ ಕಾಂಪೌಂಡ್ ಹಾಕಿದ್ದೇನೆ ಸರಿಯಲ್ಲ. ಕಾಣಿಸಿರುವ ಕಾಂಪೌಂಡ್ ಅನ್ನು ನನ್ನ ಬಾಡಿಗೆದಾರರು ಅವರು ಇರುವ ಜಾಗಕ್ಕೆ ಹಾಕಿದ್ದಾರೆ. ನೀರು ನಡೆಸಿಕೊಂಡಿರುವ ಕಾಂಪೌಂಡ್ ಪೂರ್ವ ದಿಕ್ಕಿಗೆ ಬರುತ್ತದೆ. ಅವರ ದಕ್ಷಿಣ ದಿಕ್ಕಿಗೂ ಕಾಂಪೌಂಡ್ ಹಾಕಿದ್ದಾರೆ. ಅವರನ್ನು ಒಪ್ಪಿಗೆಯಿಂದ ಕಾಂಪೌಂಡ್ ಹಾಕಿದ್ದಾರೆ. But he admits in 2003 he later compound. And later on in the class examination of defendant number 2, he says that his tenants are his permission later. Where are this matter? The documents that are produced before my lord, which I read out, P1 is the same date. P2 is the notice extract. P3 is the conversion of page 90. 97 expect P4 regarding payment of the amount for the conversion. P5 which I will start to my lord. Producer 5 to 12 of the 11 of the 46. Page 115. ಕಟ್ಟಡ ತೆರಿಗೆ ವಿಳಾಸ ಕಟ್ಟಡ ತೆರಿಗೆ paid to the CMC. ಕಟ್ಟಡ ತೆರಿಗೆ ಅಂಗಡಿ ತೆರಿಗೆ ನೀರುದರ ತೆರಿಗೆ because it is given for commercial purpose on the order. Vidyut ತೆರಿಗೆ ಸಾಮಾನ್ಯವರು paid the taxes. This is issued on 29/3/2007 madam. Before suit. P14 is the state madam. It has been produced by the painting.
Yes.
Well, I will kindly come to the evidence of TW1. Then the depends on the one has the evidence. He reiterates all the amendments made in the first statement. In the class examination, the specific question regarding consecutive marker, page 137. From the previous page, exhibit P4 ನೋಡುತ್ತಿದ್ದೇನೆ ಅದೇ ರೀತಿ ಚಿತ್ರದಲ್ಲಿ ನೋಡಿ ಎರಡು ದಾಖಲೆಗಳಲ್ಲಿ ಒಂದು ಆಸ್ತಿಯ ಚಿತ್ರವನ್ನು ಬೇರೆ ಅಂದರೆ ನಾವು ತೆಗೆದುಕೊಂಡಾಗ ಪೂರ್ವಕ್ಕೆ ಮುನ್ನಡೆಯುವ ಆಸ್ತಿ ಆಗಿದೆ. ನಾನು ಪುನಃ ಹೇಳ್ತೇನೆ, ನಾವು ಈ ದಾಖಲೆಯನ್ನು ಮಾಡಿಕೊಂಡಾಗ ಆ ದಾಖಲೆಗೆ ನಮೂದು ಮಾಡಿದ್ರೆ ಚೆಕ್ ಬಂದಿರುವುದು ಕಾಂಗ್ರೆಸ್ ಹಾಸ್ಪಿಟಲ್ ಪೇಜ್ P4 ನೋಡುತ್ತಿದ್ದೇನೆ. ಇದೇ ರೀತಿಯಲ್ಲಿ P7 ನೋಡುತ್ತಿದ್ದೇನೆ, ಎರಡು ದಾಖಲೆಗಳ ಆಸ್ತಿಯ ಚಿತ್ರವನ್ನು ಬೇರೆ ಅಂದರೆ ನಾವು ತೆಗೆದುಕೊಂಡಾಗ ಪೂರ್ವಕ್ಕೆ ಆಸ್ತಿ ಆಗಿತ್ತು. ನಾನು ಪುನಃ ಹೇಳುತ್ತೇನೆ, ನಾವು P7 ದಾಖಲೆ ಮಾಡಿಕೊಂಡಾಗ ಆ ದಾಖಲೆ ನಮೂದು ಮಾಡಬೇಕು. The boundaries stated in the
Sale deed.
Exhibit P4 may kindly receive it. In my letter and has
Yes.
taken my lot to exhibit P4.
P4 or D4?
Partition, D4.
Page
159.
That's partition. Yes.
Now, my lord, A schedule property, we kindly receive it.
In the partition deed.
That they fall into the share of page 172. Item 1 is 6 quintal, my lord. They are not to pay.
Yes.
Out of 33 quintals, they refer to pay line number 2.
Yes.
This is one property, and I am not concerned with it. I am concerned with the item number 2.
What is this document?
This is partition deed.
Aurdu.
Oh, no, sir.
Vendor.
Item number 2 is the property. It is 1 kute which I purchased under the sale deed. It is 29,000. Follow to the share of 20. Next, I want to kindly come to 174. We should know Krishnaviti.
Yes.
The meet my lad. Item number 2. When you that is the second safety 29 to go to the right. Obtain from the share of Krishnaviti.
That is your property.
That is my property. The second safety. Now page 178. That is the property fallen to the share of Undareddy, that is the second defendant. Undareddy share is shown in 175. No, 175 will always work. 175. Second portion. CH-21 దానిలాగా ఊర్నే పార్టీ ఉన్నారు ఉందరెడ్డి పార్టీ మధ్య షెడ్యూల్ చదువుతుంది సార్. ఇదిగోండి ఐటమ్ నెంబర్ 3. Out of 33 guntas,
1 gunta.
1 gunta, that is not the 1 gunta, it is actually 66 by 70.
66 by 7.
Okay.
Hmm.
Now we learn. This partition deed is marked to the plaintiff only. He has not challenged the partition deed erected between the family members and his vendors also. His vendors are also not made as parties. Once said, without document, the plaintiff is proposing his argument that the available extent is only 27 guntas, not 33 guntas. Therefore, such partition is created for the purpose of selling the property. That's to say to the market.
Yes.
My lord, the kind of the path of repetition, I don't want to say much or not. There are 3 of the same. It could be yes, correct.
How you want to read?
I want to read page 73, madam. There's a reference of data. Madam, page 27. Yes, 27. I will not understand.
2 acres, 6 guntas.
2 acres. Madam, that's for calculation. I will not understand. This time, not time. Madam, can you take 2 acres, 6 guntas amount to 86 guntas? Madam. 33 guntas have been acquired from the media according to the argument of my learned. The remaining extent comes to 56 guntas. 1 acre 13 guntas.
So 2 acres, 6 guntas is 86 guntas.
86 guntas. Deducted by 73. It comes to 1 acre 13 guntas, 53 guntas. Correct?
Yes. 1 acre 13 guntas.
1 acre 13 guntas, otherwise 53 guntas. 40 plus 13.
Correct.
Now, what has been shown? Then to him 20 guntas. The remaining extent is
33.
33. So, where is the person of saying that only 27 guntas available for the vendors to sell? According to his own document itself, his own calculation. No, it is not. Nowhere it is stated in the plain, in the plain or in the safety. Nowhere it is stated. No such document is forthcoming. Except the statement made in the memorandum. There it has been shown to Lakshmana. At the cost of reputation, when the time they come to.
Yes, yes, yes. And I remember Lakshmana shown through power of attorney order.
2.5 guntas. Not even according to him, it is not even. Therefore, madam, at any stretch of imagination, what he says, cannot test. Well, the definitely guntas is a subject matter of partition. This partition is marked to the plaintiff only. We fully aware of the contents. He admits the partition taken place and the portions allotted JDC also. And he has not challenged the partition deed, not the sale date of the defendant number 1. To say so that his extent has been and the extent shown in the partition deed is in excess of the holding of the gold. Therefore, my submission is that has no water, that argument does not hold. 33 guntas, what is available, it has been divided among the family members, that is the vendors of.
So 33 guntas remained with the original owners
Original owners.
that they have partitioned.
They have partitioned.
So what is the partition which they have entered into? Each one gets how much share?
Each one gets 11 guntas.
11 guntas.
But little more, also, but there is no implicit dispute among them. They have not been made.
All right, but somewhere that Lakshmama gets that some guntas. What about, where is that deduction?
Okay, that's precisely what they now they are saying. And it is according to him only, it is sold by Krishna Reddy and another Deva, they are not party people. It is only the minority, one of the owner is party, who is not like that.
All right.
I got to my last consideration, the base regarding C-158 mark. Two information.
Page? Sketch. This is marked as?
Marked as exhibit C, C88, C8.
C8.
The evidence of the coming from a kind of
Page.
Page 207. ನಾನು ಮುಂಚೆ ಬೆಂಗಳೂರು ಪೂರ್ವ ತಾಲೂಕು ತಾಲೂಕು ಸಭೆಯ ಕೆಲಸ ಮಾಡಿದ್ದೇನೆ. ನ್ಯಾಯಾಲಯದ ಆದೇಶದಂತೆ ಕೋರ್ಟ್ ಕಮಿಷನರಾಗಿ ಇನ್ನೊಂದು ವರದಿಯನ್ನು ಸ್ಥಾಪಿಸುವಲ್ಲಿ ಮಹಾಜನ ನ್ಯಾಯಾಲಯ ನಾನು ನ್ಯಾಯಾಲಯಕ್ಕೆ ನೀಡಿದ ಪತ್ರ C1 ವೇಗತೆಯನ್ನು ಕುರಿತಾಗಿ ನಾನು ತಯಾರಿಸಿದ C2 ಎಂದು ಮೆಮೋ ಆಫ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಕುರಿತಾದ C3 ಎಂದು ಇನ್ನೊಂದು ಮೆಮೋ ಆಫ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ C4 ಎಂದು ನೋಟಿಸ್ ಪ್ರತಿ C5 ಎಂದು ಮಹಾಜರ್ C6 ಎಂದು ನಮ್ಮ ತಹಸೀಲ್ದಾರ್ ನಡೆಸಿಕೊಟ್ಟ ಜ್ಞಾಪನಾ ಪತ್ರ ಅರ್ಥೈಸಿದ್ದಾರೆ. C7 ಎಂದು ಕಮಿಷನರ್ ವಾರೆಂಟ್ C8 ಎಂದು ಮಾಡಿದರು. ಪಾರ್ಟಿ ಸವಾಲ್ ವಕೀಲರಿಂದ ಮಾಜಿ ಪರ ವಕೀಲರು ತಮ್ಮ ಪಾರ್ಟಿ ಸವಾಲ್ ಏನು ಇರುವುದನ್ನು ತಿಳಿಸಿದ್ದಾರೆ. ಪಾರ್ಟಿ ಸವಾಲು 2 ಪ್ರತಿಪಾದನೆ. ನಾನು ಡಿಪ್ಲೊಮಾ ಬರೆದಿದ್ದರ ಸಿವಿಲ್ ಬರೆದಿದ್ದರ ನಾನು ಕಳೆದ 18 ವರ್ಷ ಸಮಯ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದೇನೆ. KR ಸಭೆ ಕಚೇರಿ ನಾನು 4 ವರ್ಷ ಕೆಲಸ ಮಾಡಿದ್ದೇನೆ. ಸರ್ವೆ ನಂಬರ್ 57 ಸರ್ವೆ ನಂಬರ್ ಮಾಡುವುದು ನಾಮನಾಮಕರಣ ನ್ಯಾಯಾಲಯದ ಕೋರ್ಟ್ ಕಮಿಷನ್ ಕೆಲಸ ಆಲೋಚಿಸುತ್ತೇವೆ. ಆದೇಶವನ್ನು ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಕಮಿಷನ್ ಕೆಲಸ ಮಾಡಿದೆ ಅನ್ನೋದು ಸದರಿ ಟಿಪ್ಪಿಣಿ ನಮ್ಮ ಇಲಾಖೆಯಿಂದ 3 ಟಿಪ್ಪಣಿ ಮತ್ತು ಅರ್ಥಾತ್ ಆಧಾರದ ಮೇಲೆ ಮಾಡಿದ್ದೇನೆ. ಈ ಟಿಪ್ಪಣಿ ಮತ್ತು ಅರ್ಥಾತ್ ಕಾಪಿಯನ್ನು ನಾನು ನ್ಯಾಯಾಲಯಕ್ಕೆ ಕೊಟ್ಟಿದ್ದೇನೆ. ಇದು ಅರ್ಥಾತ್ ನಾನು ನ್ಯಾಯಾಲಯಕ್ಕೆ ಕೊಟ್ಟಿಲ್ಲ. ನಾವು 57 ಮಂದಿ ಆಸ್ತಿ ಭೇಟಿ ಕೊಟ್ಟಿಲ್ಲ ಮತ್ತು ಆ ಸರ್ವೆ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ಸುಳ್ಳು. 29/2004 ಕೆಲಸ ಚೀಟು ಕೆಲಸ ಇದೆ. ಅರ್ಥಾತ್ ಮತ್ತು ಸ್ಟೇಟ್ ಎರಡೂ ಒಂದೇ. ಒಂದು ಆಸ್ತಿಯನ್ನು ಸರ್ವೆ ಮಾಡಬೇಕಾದ್ರೆ ಆ ಸಮೇತ ಒಂದು ಬೆಲೆ ಸಾಧ್ಯ ಅಂತ ಸುಳ್ಳು. ನಾನು ಅಳತೆ ಮಾಡಿ ಸರ್ವೆ ನಂಬರ್ 9 ಆಗಿ ಬಿಡುವುದಿಲ್ಲ. ಅದು ಅಭಿವೃದ್ಧಿ ಆಗಿದೆ. ಅದು ಅಭಿವೃದ್ಧಿ ಆಗಿದ್ದು ಅದು ಗಡಿಯನ್ನು ಗುರುತಿಸಲು ಸಾಧ್ಯವಿಲ್ಲ ಅನ್ನಿಸ್ತು. ನಾನು ಅಳತೆ ಮಾಡಿದ ಜಾಸ್ತಿ ಒಂದನೇ ಅಷ್ಟೇ ಇದೆ. ಮೊದಲು ಚಿಕ್ಕದಿತ್ತು, ನಾವು ಉತ್ತರಕ್ಕೆ ರಸ್ತೆ ಮುಂದೆ ಚಿಕ್ಕದಿತ್ತು, ಈಗ ಅಗಲವಾದ ರಸ್ತೆ ಆಗಿದೆ ಅಂತ ನಿಜ. ಈ ರಸ್ತೆ ಅಗಲವಾದ ಕಾರಣ 57 ಅಂದ್ರೆ ಆಸ್ತಿ ಸ್ವಲ್ಪ ಭಾಗ ಇದೆಷ್ಟು ದೊಡ್ಡದಾಗಂದ್ರೆ ಅದು ಓಡಿ ಆಗದೆ ಇರುವ ಕಾರಣ ಯಾವ ಕಡೆ ಒತ್ತುವಾಗಿದ್ದು ಗೊತ್ತಾಗುವುದಿಲ್ಲ. ನಿರ್ದಿಷ್ಟವಾದ ಜಾಗ ಈ ರಸ್ತೆಗೆ ಒತ್ತುವಾಗಿದ್ದು ಗೊತ್ತಿದ್ರು ಕೂಡ ಭಾರಿ ಸಹಾಯ ಮಾಡ್ತಿದ್ರೆ ಇಲ್ಲ. ನಾನು ಮುಖ್ಯ ಸವಾಲಾಗಿ ಹೇಳಿರ್ತೇನೆ, ಯಾವುದೇ ರೀತಿ ಕಮಿಷನರ್ ನಾನು ಜಾರಿಗೊಳಿಸಿದ್ರು ಸುಳ್ಳು ಹೇಳ್ತಿದ್ದೇನೆ ಸರಿಯಲ್ಲ. ವಾದಿ ಜಾಗ 57 ಕೇವಲ 22 ಗುಂಟೆ ಇದ್ದು ಇದ್ದರು, ಅದು ಕೇವಲ 14 ಗುಂಟೆ ಎಂದು ಸುಳ್ಳು ಒಂದು ಸಲ್ಲಿಸಿದ್ದೇನೆ ಸರಿಯಲ್ಲ. ಅನುಭವ ಪ್ರಕಾರ ಕೊಲೆ ಮಾಡಿದ್ದೇನೆ ಅಂತ ಕೇಳುತ್ತಾರೆ. ನಾನು ಕಾನೂನು ಪ್ರಕಾರ ಸಭೆ ಮಾಡಿ ಅನುಭವ ಮಾಡಿದ್ದರೆ ಸರಿಯಲ್ಲ. ಸರ್ವೆ ಸ್ಕೆಚ್ ವಾದಿ ಅನುಮತಿ ತಯಾರಿಸಿದ್ದೇನೆ. ಈ ಜಮೀನಿನ ಪಶ್ಚಿಮಕ್ಕೆ ಕೂಡ ಊರಿಗೆ ಹೋಗುವ ರಸ್ತೆ ಇದೆ. ಆ ಮೊದಲು ರಸ್ತೆ 8 ಅಡಿ ಇತ್ತು, ಈಗ 30 ಅಡಿ ರಸ್ತೆ ಆಗಿದೆ. ಅದರ ನಿಜ specifically admitted by you. Now, exhibit C1 mechanism. Other matters can do other mechanism. Exhibit C2 mechanism. ABCD ಯಾಸ್ತಿ ವಾರಿ ನಗರದ ಅನುಭವ ಇಷ್ಟೇ 12 ಗುಂಟೆ ಇರುತ್ತೆ. DEFG ಯಾಸ್ತಿ ಒಂದೇ ಪ್ರಕಾರ ಲೊಕೇಶನ್ ಅನುಭವದಲ್ಲಿದ್ದು 2 ಗುಂಟೆ ಇರುತ್ತದೆ. FG HIJK ಎರಡನೇ ಪ್ರಕಾರವಾಗಿ ಒಂದೇ ಇರುವ ಅನುಭವ ಪ್ರದೇಶವಾಗಿರುತ್ತದೆ. ನಾವು ಲ್ಯಾಂಡ್ ಸೈಟ್ 214 ಓಕೆ ಪಾಯಿಂಟ್. ವಾದಿ ಎಂ ನಾಗರಾಜ್ 57 ಭಾಗ ಸಿ 20 ಇಟ್ಟಿದ್ದ ಪ್ರಕಾರ ಹಾಲಿ 57 ಕೋಟಿ ಸ್ಟೇಷನ್ ಮೂಲಕ ಅಳತೆ ಮಾಡಿ ವಾದಿ ಅನುಮತಿ ಕಳೆದ ವಿಸ್ತೀರ್ಣದಲ್ಲಿ ಮನೆ ಮತ್ತು ಖಾಲಿ ಜಾಗ 12 ಗುಂಟೆ ಇತ್ತು, 2 ಗುಂಟೆ ಕಮ್ಮಿ ಇರುತ್ತೆ. ಈ ಕಮ್ಮಿ ಇರುವ 2 ಗುಂಟೆ ವಿಸ್ತೀರ್ಣ ಒತ್ತುವರಿ ತೋರಿಸಲು ಸರ್ವೆ ನಂಬರ್ 57 ಭಾಗದಲ್ಲಿ ಇರುವ ಭಾಗಕ್ಕೂ ಪ್ರತ್ಯೇಕ ಇಶಾ ನಂಬರ್ ಆಗಿರುವುದಿಲ್ಲ. For the set number of 20 guitas. Without code, no conversion can be granted. While you have still unrolled the sketcher code flag. Now my lord kindly come to page 215. This is with reference to the sketch which has been from the memo of instructions. He has answered. And notice has been signed by all the parties. Yes. Then, which is matter? Now I request my lord, not take my time, the relevant portion of the judgment may to my lord's notice the judgment portion, where how the court has come to a conclusion. On additional issue 1, 2, 3, that is held against them. And on 19 mechanism. In support of the above said contention, the defendants have produced weapon of safety. Defendants have also produced weapon of safety. As per exhibit D7, further defendants have produced weapon of safety executed by monolithy and distance on the issue as 66 feet, after 7 feet, 7 away. In D6, it specifically mentioned IT property subject to not over property. Another D6, similarly, in D7, it is also mentioned IT property subject to not over property D7. On the contrary, the schedule has shown towards south, schedule A property, remaining property 7 number 1.
So the plaintiff has to prove rescheduled property is part and parcel of rescheduled property. And defendants have enforced rescheduled property to the defendants. It is pertinent to note here that this aspect has not been proved by the plaintiff. Although in the commission report, it is shown plaintiff is having possession only 17 of property, but it does not mean rest of the property is enforced. Nowhere in the commission report it is mentioned defendant is enforced property. Court commissioner is also shown holding for the property that returns on the proof, and the holdings are in paragraph of the same dates left them. It is not a report submitted to the report committed defense has quite of rescheduled property. It is part and parcel of rescheduled property. As for version of plaintiff defendant number 2, because rescheduled property is to be 127 feet, not also 24 feet, western side 20 feet, come to 2,790.5 feet. And the graph of limitation, I would like to say, plaintiff has not produced two defendants and enforced now 2,790.5 feet of rescheduled property. The transaction period of the property. At that time, there was a road towards western side of the property, which and which is of width of 20 feet. He meets ignorance of the road widened in the year 2001, and the arch erection has not been installed. And after that, the road is built for 30 feet. He has admitted in the said road is formed with contact. Although Peterman denied using the property, road has been widened, but since plaintiff has not proved unless the enforcement is disconnected, it is to be presumed road has been widened by taking use of roads on this property. The concept of Peterman pleads ignorance with regard to property purchase the defendant on the same savings. He has specifically admitted the property purchase to the defendant of registered savings submitted to a surround side of N2D1 in the photograph confronted to Peterman. The concept of specifically admitted in 2003 started to construct hotel flat. He has submitted compound wall within N2D1 is a compound erected around the parking property. D1A is the portion of compound. D1B is the middle road erected in the building. D2 is the also photograph confronted to the D1. He has admitted with regard to the reference of D2. It is pertinent to note here that painting has erected the compound around this property to go to question of alignment. Enforcement by the defendant does not arise. Peterman has specifically admitted defendant number 1 has constructed the building for east to west policies. This by 65 feet, not also 40 feet, this 40. If feet ignorant, given 20 feet of land belongs to the defendant are all taken with such a property. Plaintiff in the pleadings has specifically pleaded survey authority for affected space. It's a knowledge in the effect of plaintiff has not produced any piece of document in its fact. The classic admitted he has not produced any other record of the score. He has admitted in the civil case. He has also shown with regard to the existence of different properties in classic domain. He has specifically admitted that the original people are living on another respect to five years. And the hotel customer will market compound activity. He does not have to submit the compound into. Again, there is already a compound towards the northern side of the defense property, towards the southern side of the Hindu property. There are abuse of video not helpful to the case of the to go for enforcement of the reasonable property. I have discussed about defense for Karnataka dispute of plaintiff of public property. So this is concerned with granting of property mentioned. So there are 27 mechanisms. I have discussed about in Chile, it has been filed by the plaintiff for relief of permanent. Thereafter, he got amended the rate for legal granted. Ultimately, the court is now by the endeavor. The evidence is specifically report dependent to property system to the side. All of the current transaction along with work. There are total business and the commission. Page 257 paragraph. The commission report is also discussed by the court. And the last mega, the court answered actual issues against the plaintiff and in favor of the defendant. And the two have to be discussed. Therefore, not the last. We need to deny the report and all the documents filed by the parties of
You are not aggrieved by the injunction granted in his favor in that 20 guntas. You are not challenged. Yes, reply. You have to say. You want to argue? Adopting. Which family member? For what purpose? Why he has to make the other family members? Maybe. What is the relief? Where is the relief he is seeking against the other family members? Sir, you may purchase the property from so many people. Whether he is seeking any relief against the family members, that is his choice. Where is misjoinder? There is a misjoinder in this. ಅವ್ರನ್ನ ಏನಕ್ಕೆ ಮಾಡ್ಬೇಕ್ರಿ? ಅವ್ರ ಹತ್ರ ರಿಲೀಫ್ ಕೇಳ್ತಿಲ್ವಲ್ಲ ಅವರು. Correct, sir. He is the plaintiff. He can make whomever he wants to make the party. All right, next. All these jobs, the plaintiff does not follow the job Yes. How much time you will take? How much time you will take? All right. You want to continue tomorrow? It's already 4:30. You'll finish it before. Okay. On the left side 28, which is the right side of A schedule property. Is understood that B schedule property is a part of A schedule. Then again, I need not to be proved that B schedule property is a part of A schedule property and separate activity is not required. But the main case is when during the interim order period not extended, where this portion has been extended. We can use the services. For what? For which they have been included in the property. When a court conclusion granting the relief of litigation in respect of A schedule property. Where in respect of B schedule property has been rejected. Section 6 of the CCP. This will be a person disposal of portion of removal property. The person is disposal without his consent of removal property otherwise than in due course of party or any person who he may be has been imposed or any person very true by him or by recovery of position thereof not to say any other crime that may be set up in this such a suit. Also under this section shall be brought up
After the expiry of 6 months from the date of disposition or against the government, no offense shall any review or any other order be allowed. Nothing in this section shall property and to recover the possession thereof. But to this extent, that is the court has not made any issue of the judgment, there is no reasoning for. For this, they will take and seek for remand of the matter.
You consider what?
Regarding the respect of the disposition of the property which has been enclosed and
So what you are going to do after remand?
we can read the matter which I think again.
No, according to him, there is no encouragement at all.
The encouragement is that the commission did not even given that the ruling has encouraged. The case is and specifically to measure the property and to identify the property, we had a sketch and to give a photograph.
You cross-examine the commissioner. Why? When the commissioner was appointed at your instance, all right, at the instance of second defendant, then whatever report he has given, if you are not cross-examined, that means you are accepted his report. Right? No, when we filed the report, you could have filed your objections to the report of the commissioner.
Commissioner after such local investigation has after refusing waiting, evidence taken by him shall be returned in such evidence together with this report in writing signed by him to the court. Report of position to the evidence this report of the commissioner and the evidence taken by him, but not the evidence without the report shall be evidence in the suit and shall form part of the record. But the court or the permission of the court, any of the parties to the suit may examine the court commission must be open for the court to consider any of the matter referred to in mentioned in this report, or as this is report as or as to the manner in which he has presented in this case. Further, when he examined this report, whether the court is or any reason as satisfied with the proceedings of the court commission, any directs us further inquiry to be made as it shall be. Where the court has been done, commissioner's report is accepted by the court or not only pending after the judgment only I can be more. For that I cannot be accepted or I cannot be accepted. Only in the passing of the judgment, the court commissioner has accepted that. But the commissioner now in an appeal, I have to hear. The commissioner's report is rendered out. I can be there.
Yes, that's all. Yes, anything? All right, now the fact remains the dispute is only with regard to the 2.5 guntas of land, which is B schedule property. A schedule property of 20 guntas is admitted by you. The question is only whether this B schedule property comes within A schedule property and whether you have enforced. That is all.
Yes, we don't think of 2007 only, when I started, in 5 days.
Correct.
Not a supplementary to pay to you. You see that I must be harassed to go. Yes, harassed. But therefore, I have a sufficient to put my life. I have raised all the material. The court has come to a correct conclusion.
No, the dispute is only with regard to B schedule property.
Yes, but issue of property is not at all in it. Because it's the permit of court.
That who has to decide? Where is the cogent material by the commissioner to the extent what is the measurement of B schedule property? What is the measurement of B schedule property? No, it is not forthcoming in the commissioner's report. Where? Sir, he has clearly given a memo of instruction what the commissioner has to do. The commissioner has to say what is the A schedule property measurement, what is B schedule property measurement, whether B schedule property is a part of A schedule property, and whether the compound put by him is there earlier or later.
We have clearly said this is a permit approach from quality to
So formation of road is not the question that was asked to be given by the commissioner. Commissioner was supposed to say,
one report is placed before me. Very commission. Authenticity and acceptability is a subject matter of appeal. Having not filed the evidence and having not said anything about the same, not cross-examining the petitioner, asked any commentary that I have given out of
the commissioner has not done the job as required. He is correct. So whether, no, I am not.
The commissioner is not been filed the evidence, not been cross-examined.
All right, sir. Now that is not done. He is now in appeal. He is now in appeal. This is a continuation.
Now, from 2007 up to the date of judgment, nothing prevented him to seek for again also because he was examined.
Doesn't matter. Now he is in appeal. This court can either set aside that order or remand the order or do whatever is required under law. Now whether
I placed an hand to the property and wrote a notice which I will.
the question of who's suffering that we will decide later on. Whether are you agreeable by yourself to go before the court for the commissioner to measure property A schedule and B schedule and give a report? Are you agreeable or you want an order of the court? Heard. Learned counsel Sri Badrinath R for the appellant and learned counsel Sri Rajana Shetty for R1 and CV Manjunatha for R2 on behalf of R2. Full stop. Matter is resolved for judgment. Yes. Next. For 8 and 9. That is the appellant. There's no representation on behalf of appellant. Learned counsel for respondent 8, 9, and 10 is present before the court. Relist this matter. after 2 weeks. Next. Next. You are ready? What about respondent? Ready? Time is not there. An injunction suit. So, prior injunction suit. All right, day after tomorrow we'll have it. We'll have it on 23rd. No. Calling. Both the learned counsel for the appellant and the respondent are present before the court. Time is 4:48 p.m. Due to paucity of time, release this matter on 23rd September. Next.
Appear for the appellant, my lords. 42, my lords.
Yes.
My lords, 1 week time, my lords.
Your senior was here in the morning.
Please, my lords, he was here.
Mr. Nagendra Naik. Monday, 26th. We'll have it on 26th, madam.
Please, my lords.
Learned counsel for the appellant is present through video conferencing. Learned counsel for respondents Sri Nagendra Naik is present for respondents. Your VB Shukumar ilva idralli. So we can delete the name. What about Anand SG and Deepthi? Satish?
She is the sole respondent, my lords.
In view of Vakalat having been filed by learned counsel Anand SG and Deepthi along with Sri Nagendra Naik, the registry is directed to delete the name of learned counsel VB Shivkumar and A Satisha from the cause list. Registry to spell the name of learned counsel Nagendra Naik properly as Nagendra NAIK. Nail and the Madbutigar. It will not come with you.
Thank you.
Yes. Any difficulty?
ಸರ್ ಇವಾಗ